Hi. Okay. So I got both rooms open, just so y'all know. The Sandra thing is it hasn't started yet. So I opened up the room, but yeah, it hasn't started. We're live. I'm not doing any TiVo time, just on a repeat, just so you guys know. Um, we just kind of waiting. So if once they start, we'll be live in there. And those that were watching the Zach Adams, you're more than welcome to continue watching the Zach Adams. And as soon as the trial starts, I will let you know. All righty.
Shanda Vander Ark.
All right, Ms. Vander Ark, if you can come around here, please.
Stand in front of that chair, raise your right hand, please.
Raise your right hand, please. In this matter now pending, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do, yes,
All right, you can put your hand down, grab a seat. Please state your name for the record, spelling your first name and last name.
Shanda, S-H-A-N-D-A, Vander Ark, V-A-N-D-E-R, space, capital A-R-K.
Thank you, Ms. Vander Ark. You're being called to testify in your own cases. You understand that?
Yes, sir.
And to do that, you have to make sure that everyone can understand you, correct?
Yes, sir.
With you, and knowing you as I do, I don't think volume's gonna be a problem with you.
Probably not, sir.
Talking fast, maybe.
Yes, sir, it might.
Okay, so this is, are you nervous?
Yes, sir.
This is stressful?
Yes, sir, very.
So questions gonna be thrown at you, fast and furious. You've seen how trials work, correct?
Yes, sir.
Okay. And under those circumstances, you may speed up again as I do.
Yes, sir.
Okay. You may be reminded from time to time to slow down just a little bit. Do you understand that?
Yes, sir.
Okay. All right. Let's make sure everyone understands you. You've been sitting through this trial since the beginning, correct?
Yes, sir.
And you were arrested for these offenses alleged back when?
July 7th of 2022.
Okay. So you've been living with this thing for more than, 18 months?
17 months. Yes, sir.
17 months. So you know what we're talking about, correct?
Yes, sir.
And you understand the allegations against you?
Yes, sir.
And that it also helps that you have a legal background, correct?
Yes, sir.
Okay. The things they said about how well you did in school and all those things, were those all true?
Yes, sir.
Okay, I want you sitting there and regaling this, but the things about cum laude and going to law school, all that stuff is true.
It was magna cum laude. Yes, sir.
Okay, thank you. All right. Let's go back to the very beginning. When did Timothy come to your care?
May of 2021.
Prior to that, who had physical and legal custody of Timothy?
My ex-husband.
Okay. And when he sent, and how did it happen that you ended up with custody then?
My ex reached out to me, stating that Timothy he could no longer handle him, that he was pushing his buttons, and that he needed to send him to live with me.
Okay. And you agreed to that?
Yes, sir.
Okay. Had you ever lived with Timothy during his?
When he was younger, yes, sir.
Okay. All right. So you agreed to accept him into your home?
Yes, sir.
And who was living in your home at the time?
Myself, my husband, Adam, Paul Ferguson, and then my little man, G.
G. Okay, that's what we've been calling G, correct?
That's really hard to do. Yes, sir.
Okay, just do the best you can. Okay, so they're all living in your home, and then Timothy joins you, correct?
Yes, sir.
When Timothy's joining you, did your ex-husband ever make any effort to transfer legal custody to you?
We discussed it, but he never did actually sign anything. No, sir.
Okay. And without legal custody, how do you get Timothy into school?
You can't.
And without legal custody, how do you get medical treatment for Timothy?
You can't.
Did your husband at least send I assume he had medical insurance for Timothy. Did he send that?
He did not send me. I requested his medical card, his insurance card, and he never sent it to me.
Now, you heard the testimony that Timothy saw the doctor in 2019. Did you hear that?
Yes, I did.
That was a year before you received him?
2 years before I received it.
2 years before. So the prior 2 years before you received him, as far as you know, based on what you heard here, your ex-husband never took him to the doctor?
As far as I know, yes, sir.
How do you know if he had medical insurance for this young man?
He told me he did.
Okay. But he never sent it to you?
No, sir.
Okay. What was your financial situation once Timothy arrived and your husband had a stroke?
After the stroke, we
Yeah.
lost my husband's income, and it was paycheck to pay, not even paycheck to paycheck. Almost everything was paid late. I was struggling. I asked Paul for help with groceries sometimes because we were struggling.
Okay. And Paul was working full-time?
He was working part-time.
He's working at Applebee's? Is
Yes,
that- Okay. So he's working part-time, and so were you receiving any child support?
No,
So the entire financial burden was on you.
correct.
Could you have afforded daycare for any of your children?
Absolutely not, no.
And could you have afforded any extra expenses other than the ones that you were providing for?
No,
What type of expenses were you able to provide for this family?
just basic living expenses.
Rent,
Yes, sir.
utilities,
Yes, sir.
food?
Yes, sir.
Okay, that leads to the next question I have for you. You had monitors and cameras in your home, is that correct?
Yes, sir.
And the impression from the testimony I heard is that it was for the sole purpose of ensuring that Timothy could not get the food. Is that accurate?
No.
Why did you have all those monitors and cameras in your home?
When Timothy came to live with us, his stepmother informed me that they'd had motion sensors. They weren't as tech savvy as I was. I worked in tech before law school. I worked in tech support for several years. But they had motion sensors and she told me that she didn't sleep at night. She only slept when he was at school because he was into everything. And so because my younger child, he used to, when he was about 2, he would take all his clothes off. So we started putting a camera in his room. And then once we moved to the Marshall Road location, it was bi-level. My husband was born with a disability. My husband was wheelchair bound. So we had an extra wheelchair that we kept on the upper level. That's where the master bedroom was. But that way, if G was down in his bedroom, my husband could talk to him through the camera and have him come up. It was much easier. My husband could crawl down the steps before the stroke, but we didn't want him to have to crawl up and down those steps.
Okay. And again, let's go back to the issue of food. Was food the only reason why you felt you had to monitor Timothy, or were there other issues?
There were plenty of issues, sir.
So, well, first of all, what we've heard some testimony as to Timothy's special needs. What were his special needs?
He was on the autism spectrum, but he was completely verbal and he was grade level in school. He was not behind in school at all. He was diagnosed with attention deficit hyperactivity disorder. He was diagnosed as bipolar and sensory processing disorder. I heard Paul mention physical disability. He didn't have any. Now, Timothy, when he first got there, said he had a physical disability, and I asked his stepmom about it to make sure, and she said no, he was not coordinated at all. The first summer that he lived with us, my youngest was playing baseball, and Timothy actually mentioned, because we had planned to put him in public high school, I'm going to try out for the baseball team. And I didn't say anything to him, but I remember thinking, sorry, sweetie, there's no way. You don't have the coordination for that.
All right. And he liked to take, well, you tell me, did he like to take things apart?
Oh, yes, absolutely.
Can you give some examples?
He took batteries apart. He took toys apart, my youngest son's toys. If he could get a hold of anything from Paul's room, he would take, like, mostly it was Legos. Paul still had Legos. He, at one point, messed with our water heater.
What do you mean?
He actually turned the gas off to the water heater. He knocked out the pilot light and then turned the gas off as well at different points.
Okay. Did you have any concerns as to whether or not his predilections, his desire to get into things might be a safety hazard for either him or somebody else in the home?
I was extremely concerned about that, yes, sir.
So it was your desire was it just your desire to monitor Timothy, or did you also have a younger child in the home that you wanted to monitor?
We had both.
Okay. Who did you want to monitor? One or the other, or both?
Both.
Okay. All right. So you set up these video and audio cameras, correct?
Yes, sir.
Okay. And alarms on the doors?
Those didn't get installed until about 3 weeks before he passed away.
Okay. And motion sensors?
Yes, sir.
Okay.
He got around the motion sensors multiple times.
Were you able to stay home and personally monitor your children?
No, I had to work full time.
Okay. How were you able to get Timothy into school?
No, we were not. We tried to enroll him in Mona Shores High School, and Mona Shores told me that my ex, I guess Timothy had damaged a Chromebook in Oklahoma, And because my ex owed money on that, they would not send his records up to us. So we were not able to enroll him. So I found online homeschool curriculum that I had to monitor, but I enrolled him in that.
Let me make sure I understand. Was it your original intention to put Timothy into public schools?
Yes, sir. We started the process. I filled out the paperwork. Because of my work schedule, I couldn't actually take paperwork to Mona Shores. My husband did that. Adam did that. But yes, we did try to get him enrolled.
Okay, and the youngest child, G, was he in public schools?
No, he was homeschooled.
What about Paul? Do you know if he was homeschooled or if he, when he got to you, was he still in school?
No, he had graduated high school.
Okay. All right. Okay. Now, you mentioned that you weren't able to stay at home and care for your children at home, in the home, as a stay-at-home parent. Is that correct?
That's correct.
And what type of, I assume you're out working?
Yes, sir.
Okay. Explain to the jury the work that you did during the period of time that Timothy arrived in your home.
When he first arrived, I was still studying for the bar exam. So my husband was working full time. And I was just doing, I trained dogs on the side, everything from basic obedience up through different types of service dogs for other people. And so I had a couple of dog training clients, but mostly I was studying for the bar exam. I also was an intern here in this courthouse.
That pay a lot of money?
Oh, it was not paid at all, sir.
Okay.
But it was the week of the bar exam. My judge that I worked for here as a law clerk informed me of this position that was open in Waco County, and she knew that the judge referred me, and that's when I did the interview, and I started work. I think it was 2 days after I completed the bar exam.
Okay. Was that a paid position?
Yes, it was.
Was it lucrative enough where you didn't have to do any other work?
Well, with my husband's income, it was.
Okay. But your husband's income stopped when he got sick?
When he had the stroke, yes.
Okay. So at that point, was it enough income to provide for you and your family?
No.
Were you receiving any other outside incomes?
My older brother lives in the home that I still own in Oklahoma, and he paid rent to us, but
Okay.
it wasn't a lot. That went towards our house rent.
Child support?
No, my ex, one of the siblings was forgotten yesterday. There's 5 total. We talked about the 4 boys. I also have a daughter. She is now 19, but she stayed down with her dad.
Okay.
So we each had one, so there was no child support. And because of child support on the other 4 kids, I actually was still paying my ex child support. It was still being deducted from my check.
Okay. So you had that's another deduction from your income?
$1,000 a month, yes, sir.
Okay. So, were you also doing tutoring when you went to the judge who was paying you? Were you still tutoring or doing any other outside work?
Not at that. I was doing the dog training.
Okay. Let me ask you this. What time in the morning did you leave to go to work?
I usually left the house about 6:30,
And what time on average were you getting home?
about 6 o'clock.
Okay. So we're talking about 12 hours away from the home.
Yes, sir.
Okay. Those monitors, the video cameras in your home, you were able to view them while at work?
From my phone, occasionally, yes, sir.
Okay. But you were still working?
Yes, sir. I didn't view them at all until after the stroke. I mean, because my husband was there, or we had arrangements where my husband was off certain days of the week. Paul was off one day, specifically one day a week. So he took care of Gabriel and Timothy. And then the other 2 days that I needed care for Gabriel when my husband was working, he actually went to my in-laws' house down in West Olive.
May I approach the witness for just a moment, John? You may. Let's see. You have 3 children at home.
Yes, sir.
Okay. And my understanding is you faced other challenges personally in terms of your own personal health. Is that
Yes, sir, I
correct?
did.
Okay. For instance, let's run down the list. You had insomnia.
Severe insomnia caused by attention deficit hyperactivity disorder.
Okay. And for those folks who get a great night's sleep every night, don't understand what insomnia does to your ability to function, can you explain to them what impact chronic insomnia has on a person?
limits your ability to think clearly. Your energy level is greatly reduced. Takes a lot longer to process things. You forget things easier. It was much harder to function with so little sleep.
Okay. And you talked about your other personal disorders. Were you receiving medications for those?
I was for, I have severe attention deficit hyperactivity disorder combined type. I also have sensory processing disorder and OCD. And then after my husband's stroke, as a result of my husband's stroke, because I viewed him, I wasn't in the room when he had the stroke, but I was there right afterwards. And so I developed post-traumatic stress disorder with disassociation from that. The only medication that I was on was for the ADHD.
Okay. And you had the service dogs in your presence too?
I had one service dog for me, yes.
Okay. What sorts of interventions were available for Timothy's disorders?
When he came to us, he was on medication. They gave us a whole large gallon-sized Ziploc bag of medications for him. I could not refill them because I could not get him to the doctor. We were going to try to adjust his medication because when he came to live with us, when he took his medicine, he was a zombie. It was just horrific. And when Paul came to live with us, because Paul had only been there a year when Timothy moved up, sorry.
Well, gosh, that was a weird place to pause that. Okay, I just had to close down the other room. I caught myself trying to have these kind of scheduled appropriately so we could have watched the first half of Jason Autry's testimony. That was supposed to end. Then we were supposed to go right into here, and that's why we kind of started so early today. But of course, they had a schedule for 7:00. It still has not started. So currently right now we have on a testimony from, we have on her testimony, her prior testimony from her prior trial. So we'll continue to listen to this. And as soon as they take us into the courtroom, I will take us in there live.
Mm-hmm.
And when Paul, he was on the same big bag of medication. And there were serious concerns that they just, instead of handling, especially my ex, he wanted to medicate them, but I never got that option because I couldn't take him to the doctor.
Okay. All right. There's been some allegations, let's get some implications, put it that way, that you tried to keep people from seeing Timothy, that you tried to keep him away from public view, that he didn't go to school, he didn't go to the doctor, etc. That he went outside, he was in the backyard. Do you remember that testimony?
Yes, sir.
If someone's outside in your backyard, are there trees or fences or other obstacles to keep the neighbors from looking over there and seeing who's out in your yard?
No, there was a clearing before, there was woods at the back of the lot, but there was a clearing, and at least the neighbors on each side, there were pretty sizable windows on the back of their homes. They weren't I think the next door was a 2-level, but the one on one side was just a single level. It may have had a basement, I don't know. But there was big windows and they could see into our backyard easily.
Okay. Was it ever your intention to keep people from seeing Timothy?
No, my mother-in-law saw him. They do rental home inspections, I guess the city of Norton Shores. I don't remember if it was late April or early May of 2022, but it was in that neighborhood. And so we'd had the inspection that day, and my mother-in-law happened to stop by that day. And I invited her in. We sat and talked, and Timothy wanted to come say hi. So he came up and said hi to her.
Now you're a Muskegon County transplant, correct? You're
Yes, I'm not from around here.
So and I'm assuming that your direct biological family, there's not a lot of them in this county?
There's I don't have, other than my children, I don't have any biological family here.
Okay. How far away are they?
My older brother is in Oklahoma City, and then I have 2 sisters that I have not talked to in over 20 years, and they live in Alabama, where I'm from.
Okay. So how often do those folks, your bio family, stop by and to see how sister's doing?
The last time I saw my older brother was when we went down to North Carolina for my oldest son's wedding in October of 2021, and then my brother and sister-in-law drove over from Oklahoma for the wedding as well. We FaceTimed a lot. We watched football games on FaceTime, but I didn't get to see them after we moved up here.
Okay. Do you have a lot of friends in the area that will come by, will stop by does it happen to be in the area, that sort of thing? They'll come by and visit your home?
Most of my friends were from work, and they actually, because I worked in Newaygo County, they lived in Newaygo or Oceana County, or even further. I don't know. I'm not from here. I don't know what county is next to Newaygo east. But I know at least one person from work lived in, I think it's Big Rapids.
Yes.
So no, they didn't stop by because they were too far away.
Did you have a lot of time for social interactions at your home?
No, not at all.
And how about Paul? Did he have friends that he'd bring by, or?
No, he talked about people at work, but he never asked to bring anybody over.
Was he ever given any instructions? You can't have people in this house?
Absolutely not.
And what about the youngest child, G? Did he have any friends for sleepovers or anything like that?
We didn't have any friends over for it. No. He played baseball. Because of me not being able to get out, he didn't get out a lot. I mean, I wish I could have gotten him out more. That's why we put him in baseball, so he could get around other kids more. I had been looking into homeschool co-ops, but with my schedule, I just couldn't do that.
Okay. What would you say was more impactful in terms of your, get Timothy out of the house? Was it your desire he not get out of the house, or your work requirements?
It was work requirements and his choice. I want to say it was April. The weather was halfway decent. I guess people here there was kids down the street. There was teenagers playing basketball when I came home from the grocery store one weekend.
Mm-hmm.
And I stopped and rolled my window down and said, hey, I've got a 15-year-old at home. Can he come play with y'all? Even though I knew he wasn't coordinated, I thought he would enjoy it. And they said, yeah, sure, absolutely. And he did not want to go play.
Okay. Did he ever request to go play and you denied him?
No, he never did. Actually, Paul, we had mom and dad, my in-laws, got Timothy a bike for his 15th birthday. And Paul and we were on a cul-de-sac. And Paul had tried to teach him to ride the bike.
Okay.
I know they had a few sessions. I don't know how many.
Okay. So on those occasions, he'd be outside.
Oh yeah, he was out in front of the house on the cul-de-sac.
Okay. All right. Okay. Let's talk about some of the things that have come up in this case. There were leg irons discovered in your home. Were you aware of those?
I was aware that Paul had them. You actually could look on my Amazon. Paul had the option to do payment on the Amazon as well as mine.
Uh-huh.
And Paul had actually ordered those under his account.
Okay. You did not order the leg irons?
I did not, no.
Did you ever use them?
No, sir. No, I never instructed.
Let's be in specific. Did you ever use them with Timothy?
No, sir.
Okay. Did you ever notice any bruising on Timothy's wrists or legs that might be attributable to the use of leg irons?
No, sir. I never saw anything like that.
You heard Paul talk about plastic ties. What was that about?
I honestly don't remember.
Okay.
I don't know why we would order. I mean, I saw the ties. I don't remember ordering them. I don't know what happened there.
You're gonna say I don't remember a lot, aren't you?
Unfortunately, yes, because of the dissociation.
Okay. Explain to the jury what that means.
Well, I guess there's different forms. Somebody told me this. I did not find out about the PTSD and the disassociation until about 7 months after my husband's stroke, even though it had been going on since the stroke.
I need to place an objection on the record, and I think we're going to have to excuse the jury.
Okay.
The jury?
We'll have to excuse you back to the jury room. You may be seated. Mr. Roberts, you can continue.
Thank you. Before we get back to the question I originally asked Ms. Vander Ark, you just obviously had quite a visual reaction there to the jury, a physical reaction in front of the jury looking at those photographs. That's not the first time you've seen these photographs, though, is it?
No, sir.
In fact, you sat in this very courtroom not even a week ago on Friday when we had a hearing about those photographs and looked at those photographs, didn't
I
you?
did not look at them last week, sir.
You didn't look at them last week?
No, sir, I did not.
But you've looked at them before, haven't you?
I think it was at the prelim, and I gagged that day too. It just wasn't as bad.
Didn't throw up.
No, it wasn't as bad.
So if there's video from that hearing that we had last week where you thumbed through the photographs, including the autopsy photos without vomiting, do you just not remember that as well?
We didn't have the autopsy. We didn't have those photos over at our table, sir. It won't be on the video. I can promise you that.
Well, then I'll return to my original question. Those 3 photographs depict your son hours after you supposedly put him in a warm bath. Did he look like that when you put him in the warm bath, but for the fact that he was alive?
I did not look at him, sir. He was 15. I tried to give him his privacy. It may sound lame, but I intentionally look away. That's why Paul did most of his baths, is because he's 15 and I didn't think that was appropriate.
So you didn't put him in the bathtub?
No, he was already in the tub. I just looked.
Did you get him out of the tub?
I don't remember. I think so. Later that night, I would assume so.
Later that night, how long was he in the tub?
Well, night to me is any time after work. So
Okay. How long was he in the tub?
I don't think it was long after I got home, but I don't know.
And again, you didn't tell the police officers this when they talked to you about what had happened the night before, did you?
I don't remember. Apparently I didn't.
Well, so you don't remember what you told the police officers?
I remember part of it, but I mean, if you say I didn't tell them, then I trust your word there.
If you told the police officers that you noticed he was skinny, so you made him some bread and put some butter on it and watched him eat 3/4 of it and then sent him to bed, does that refresh your recollection about what you told the officers?
I mean, I hear what you're saying. I don't remember saying it, but
So you don't remember saying those things to the police officer?
no, sir.
And those things clearly didn't happen, did they?
No, sir.
How did he get into his room that night?
I don't remember, sir.
Last page of the text messages. You can go ahead and read that very top text message, please.
Please set your alarm for 6 a.m. I ended up dragging him back to his small room because I wasn't going to risk him having access to the tub or other things overnight. He's still trying to be stupid, but I will tell you more tomorrow while I take you to work, describing how many different ways I proved that he's still faking. He's still doing it, though. It's beyond ridiculous.
I ended up dragging him back to his small room because I wasn't going to risk him having access to the tub or other things overnight. Plan was for him to sleep in the bathroom, wasn't it?
I don't remember, sir. I mean, I know that in the text message, but if that's what the text message says.
Okay. And you had to drag him back to the small room. Again, the small room being the closet, right?
Yes, sir.
Supposedly that he wanted to sleep in.
Yes, sir.
But you had to drag him there. Why was that?
Oh, dragging, I mean, that could be anywhere from grabbing hold of an arm and because someone's not being cooperative. That can be a range of things, sir. So I don't know what I was referring to there.
You've seen the video, haven't you?
No, sir. I haven't seen any videos.
Do you need your memory refreshed about him getting back in the small room that night?
No, sir. I mean, like I said, I don't remember actually doing it.
Did you physically pull him into the room that night?
Yes, sir. I mean,
And did you push him down onto the ground so that he was laying and facing the camera?
if that's what it shows, then yes, sir.
And did you position his face towards the camera?
If that's what it shows,
And did you tell him that he owes you the biggest apology on the face of the earth, and then maybe he can get out to go to the bathroom?
if that's what it shows, sir, I don't remember.
And did you return a little while later because he had rolled over away from the camera so that you couldn't see him on camera?
If that's what it shows, I don't remember any of this.
And did you tell him you don't need to open your mouth every time you breathe, dummy, and then hold his mouth shut?
I don't know what I said, sir. I mean, I'll take your word for that's what the
Oh,
video
you don't have to
shows.
take my word for it. Let's play the video for you.
Sir, that's not necessary. If that's what you're saying it shows, I believe you. I'm
So
not.
you're acknowledging that the night before Timothy died, hours before he died, you dragged him, looking like that, back into his small room, positioned him in front of a camera, told him he owed you an apology, then came back later because he rolled over away from the camera and held his mouth closed and said, see, you don't have to open your mouth when you breathe, dummy? You're acknowledging you did those things.
If that's what the camera shows, yes, sir.
You didn't put him in a warm bath that night, did you?
Yes, sir, I did.
But you had to drag him away from it?
If that's what it says, I don't. I know that I know he had a hoodie on.
You said the locks on the refrigerator were there because he got into the refrigerator, and if I heard your testimony correctly, he ate a pound of frozen hamburger
Yes, sir. That was back.
and a bag of chicken nuggets
A frozen bag of chicken nuggets, yes, sir.
and frozen hamburger,
Yes, the hamburger was not frozen, it was refrigerated.
but frozen chicken nuggets
Frozen chicken nuggets and raw bacon.
and raw bacon.
Yes, sir.
Frozen raw bacon?
No, it was in the refrigerator.
The frozen stuff was the chicken.
The
Chicken
chicken
nuggets.
nuggets, that was the only frozen, yes, sir.
Did you think he had an affinity for frozen food?
I didn't know the only thing he ate frozen was the chicken nuggets.
Is that why you sent a text message to Paul while he was in the ice bath at 3:43 that afternoon and said, oh, okay, crazy thought. Tell him if he actually sits up by himself and stays sitting up, he will get some pizza rolls. Don't tell him it's only 2, and I'm okay if they are frozen rather than cooked. Why'd you send that text message?
I don't know.
Don't remember that one either?
No, sir.
So you're not worried about him eating frozen pizza rolls if he sits up?
If that's what it says.
You've heard it read several times. You're
Yes,
not
sir.
doubting that's what it says, right?
Yes, sir.
Just another one of those memories that you just gone from your head, right?
Yes, sir.
So when you told Detective Peasky that the reason the locks were on the refrigerator is because he would get into them and he'd leave the doors open, that was a lie, wasn't it?
No, that was also true. He did that as well.
How does putting locks on fix that problem?
He can't get into it then, so it doesn't get left open.
Oh,
No,
so
he was
he
the
wasn't.
only
So
one.
you admit that he was not allowed access to the refrigerator or the freezer or to the pantry.
As far as the refrigerator, freezer, after we put the locks on.
He couldn't get into them, could he?
No, not after that.
And the pantry had an alarm on it as well, didn't it?
No, it didn't.
Okay. We'll move on. We can circle back to that. Let's talk about some of the other things that you told Detective Peasky. You told Detective Peasky that long after the stroke happened in January, Timothy went on a hunger strike. That was a lie, wasn't it?
Not long after. And no, that was not a lie. That was the truth.
He went on a hunger strike.
Yes, sir, he did. It wasn't immediately, but it was within a few days.
And a hunger strike is refusing to eat, right?
Yes, sir.
So he's refusing to eat food not long after your husband has a stroke, right?
Yes, sir.
Then you don't need to put locks on the refrigerator or freezer, do you? If he's refusing to eat.
He stopped. He started eating again.
He started eating again, so then you decided he's been on a hunger strike, he's eating again, so now we better lock up the food.
No, I did the locks to protect him because he could have killed himself eating the chicken nuggets. I didn't put the locks on after he did the hamburger or the bacon, but the chicken nuggets, it was raw chicken.
Chicken nuggets are cooked, aren't they? They're pre-cooked.
Are they? I didn't even think about that.
But it's okay if he has a frozen pizza roll or two, if he sits up, right?
Yes, sir.
February 18th, 2022. Find out what he has snuck right the heck now. Because I know he has snuck all stuff since you weren't doing what you were supposed to. What do you mean you didn't know he was awake? You both should have been awake at 10:30. I am not happy. You know he wasn't just sitting there. Check the brownies in the kitchen. Check everything not locked away. Check where the flipping keys have been. So starting February, you had to lock up all the food. Make sure he's not getting into the brownies, right?
And all of the food was never locked. There's no pictures of it, but one of the lower cupboards had quite a bit of canned food in it. And he actually would get into that and eat stuff out of cans as well. But there was never a lock on that lower cupboard. I don't know if I know they took pictures of it because I showed it to them.
So he had access to one cupboard of food?
The pantry wasn't locked the whole time. I know that.
But there were times the pantry was locked or had an alarm on it, wasn't there?
There was no alarm. I never got one for the pantry. I've heard the text messages. I don't remember there being a lock on the pantry, but I've heard them.
228, check his breath. I can almost guarantee he's eaten something. He was chewing on something when he walked downstairs. You and I will be talking about this on a later date when we're both home. Paul's response, yes, he grabbed some chips. I know. So he wasn't allowed to eat chips on 228 at 4 o'clock in the afternoon. Couldn't have some chips, right?
I mean, I don't know what happened in that situation.
Well, you didn't say make sure he didn't get into the frozen chicken nuggets because it might kill him. You said find out what he's been into, and Paul says he's been into chips, right?
That's what it says, yes, sir.
So I imagine the next text message then is, oh, great, that's fine, he can have some chips.
Well, no, the point of it was he was sneaking things. He knew better.
Couldn't have chips.
It wasn't that he couldn't have chips. It was that he would sneak things. It
So
was
how would he-
dishonest.
How would he earn getting chips?
He didn't have to earn them. All he had to do was ask. I was trying to teach him not to sneak. He snuck. It wasn't just food. He would sneak in the garage. He would sneak toys. He snuck around and messed with his baby brother's homeschooling materials. I've got like flashcards and stuff for him. He messed with those and got them all out of order.
March 4th is around the time that you acknowledged that he was in zip cuffs. We talked about that a little bit earlier, but I don't think we clarified your final text message where you said, you know what? We will start cutting off the ends once they are tight, so he can't do that. Is that one of the can't remember texts too?
Yes, sir.
Mm-hmm. March 19th. Okay, that only makes partial sense. What did he grab? LOL. Paul's response, I don't know, chips or something small he had in his pocket. Okay, tell him he just restarted is not eating again. That was you. March 19th. Tell him he's just restarted is not eating again. So he took chips. So the punishment for that is now he's not allowed to eat anything again, right?
I don't remember, sir.
Don't remember that one. Okay. Talking about the punishment outside. Paul says, wall sits question mark, and they say, push him until it looked like he is about to fall over, please. That was for running up and down the stairs, wasn't it, on April 14th?
If that's what it says, yes, sir.
So you wanted Paul to run him up and down the stairs until he was ready to fall over.
That's what the text says.
What crime had he committed to warrant being physically driven until you fall over?
I have no idea, sir.
April 18th. He managed to come upstairs, yank the locks off of both the freezer and the pantry without you noticing, and he stole a bunch of crap that squished and rattled and did all sorts of stuff, and you slept through everything. KK, no devices until tomorrow, at least my lunch other than messaging, until at least my lunch other than messaging me, which would be very little. Remember that?
I don't remember it, no, sir.
So, but if the text message said he yanked the locks off the pantry, then there were locks on the pantry as of April 18th, right?
Apparently.
$426, almost freaking caught him again. I want all the food in the fridge, freezer, or pantry, and those locked. So locking up all the food again on April 26th, correct?
Well, the cupboard still was never locked.
And what was in the cupboard?
Canned a bunch of canned stuff. There's a bunch of cans in there.
Bunch of cans in there?
Yep.
So you're okay with him getting into a bunch of canned stuff?
I mean, he got into it all the time.
So what do you go to the drawer, get a can opener, open up the can, put it on the stove, warm the stuff up?
No, he didn't. He would eat it straight out of the can.
But that
It's
didn't worry
weird.
you. That didn't worry you?
Well, when I discovered it, it did, but I just never put anything on that cupboard.
So what caused this almost freaking caught him? And when all the food in the fridge and the freezer, the pantry, those locked up, April 28th.
I have no idea, sir. Without having it in there, I don't know what caused it.
It's likely related to the text before that, isn't it?
I don't know.
He keeps pulling his arms down, and that doesn't set off the camera alarm, so please watch him for that. Well, why did he have his arms up?
He was standing against the wall with his arms on his head.
So he'd have to do that for long periods of time, right?
Stand there, but he didn't have to have his arms up the whole time, but I'd set a time limit on how long he had to have his arms up.
And you're watching or watching an alarm to make sure his arm doesn't go down, right?
From the sound of it.
The response to you about from Paul about locking up the food, it's just he pulled the pantry door lock. What do you mean he just pulled it? Did he take it off? Paul says, yes, that part that attaches to the wall is dangling right now due to sticky locks. Okay, get another one on it right away. Last I saw, they were on the floor in a bag in my room. And you need to make him run up and down the stairs a ton for that, even in the golden rain. So trying to take some food, not in his cabinet full of canned goods, and pulling a...
Okay, so guys, they have started the hearing. I'm gonna put us in there. Oh gosh, she look a mess. Oh gosh. Dang. She don't even look like the same person. But here we go. Wow. Dang. Look like she done picked up a little weight. Okay.
I think everyone every time we go back upstairs.
Circuit Court, County of Muskegon is now in session. The Honorable Matthew R. Case was presiding. Please be seated. Good morning.
All right, before the court is file 23110 FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right, Ms. Vander Ark appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Date and time, the court is scheduled for a Ginther hearing and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self. And so that concerned me. So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time. And so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday, she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. I'd like to move forward if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can, with any type of confidence, say that. So I would still ask for an adjournment. And I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that she had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes,
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
Okay.
She has a pounding headache, and it doesn't help. It's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah,
Do you have, as an officer of the court, do you believe she's not competent to go forward? Under the Michigan, under the law in the state of Michigan, do you believe she is competent to go forward?
Yeah, I don't think she's incompetent, put it that way.
Okay.
She's able to communicate with me, yes,
Okay.
but maybe, not at the best.
All right. Does she,
Especially with somebody that has a pounding headache. I can just imagine.
Did she take any medication for
I don't think,
headache or aspirin or
I don't think they gave
ibuprofen or,
any medication today.
okay. Is that something she normally would take for a headache?
Yes, she's,
Okay.
oh yeah, she does, she has a thyroid issue. She pointed out to me,
Okay.
that it's protruding. She's undergoing testing. Won't know the results for another couple of weeks if
Mhm.
it's cancerous or not. There is a family history of that as well.
Okay. Ms. Bloomquist.
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have after the in-chambers discussion, jail medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Okay. Did anyone, we obviously have the Department of Corrections officers in the courtroom. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they may be needed to take some brief testimony.
Well, short of that, I mean, are either one of you comfortable doing that?
If you would like us to, we can.
Okay, well, why don't we have one? What's your name, ma'am?
Officer Scott.
Officer Scott. Why don't you have you come on up and I'll swear you in. What's your first name, ma'am?
First name's Autumn.
Autumn.
A-U-T-U-M-N.
All right, Ms. Scott, can you raise your right hand? This matter not pending. Do you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn, A-U-T-U-M-N. Last name is Scott, S-C-O-T-T.
All right, any objection with me asking some questions, and I'll let you guys follow up. Mrs.
Okay.
Bloomquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen. So,
That's okay.
my understanding is you transported Ms. Vander Ark here this morning. Is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Ypsilanti, Michigan.
Okay, approximately how long is that?
About
ride?
2 hours and 45 minutes.
Okay, and now I kind of understand the configuration. Are you in the back with her in the van, or are you driving in the front? How does that usually work? Where's everybody in the van?
I was, it's okay. I was driving. My partner was in the passenger seat and Miss Vander Ark was in the back.
Okay, so you were more focused on the road?
Correct.
Okay, all right, so we probably need your partner more a little bit. Now, were you able to observe Miss Vander Ark?
I can see her through the rear view mirror as I drive.
Okay, was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay, did she indicate that she had a headache at all?
She did not. When we arrived, she did say that she was feeling a little nauseous,
Okay, all right.
a little dry heaving.
Okay, anything from, was it, no, okay, all right. You probably, did you ask what it was from? Was it from the ride or something like that, or you don't, you know?
She did say she does get car sick.
Car sick, okay, all right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay. Okay, all right. Technically, Mr. Ambrose, this is your hearing, so unless you want to go ahead, Mr. Ambrose.
I don't really have anything.
Okay. Ms. Bloomquist?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. Like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Okay, you can stand down. Thanks so much. Do we want to put the other Department of Corrections officer on? Anybody input on that?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right, any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that's consistent with, her headache, what she reported to me.
All right, Ms. Bloomquist, anything else?
Yes, Your Honor, I just would ask the court take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in the in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that. But as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right,
Your Honor, can I just say, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you and what kind of, I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel. And so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly appeared to be situational. Also, when she were at a preliminary examination down in district court, there was a point of what she's claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that adjourning this would necessarily prejudice the defense. However, there's witnesses here, they're ready to go. People took time out of their schedules. The court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of fact at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statements. So I'm willing to do this. I can take a break, wait for the records to come in. That way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay. All right. So I don't if we have something downstairs. She can, I don't know what she takes, Mr. Ambrose. She'll let me know. I'm sure they have it all on. We can do anything we can to help with that. I'm willing to give her, if she needs for blood pressure, I don't know, maybe she needs food or something. I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail. And then we'll go from there. Anything else before we break, Ms. Bloomquist?
No, Your Honor.
Mr. Ambrose?
No, thank you.
Okay, we're in recess.
Okay, guys. So they're on a short break. What do y'all think? I noticed Samantha's hearing is going on right now for her sentencing. Do you guys see what's going on? And if for y'all that don't know, Samantha Cribbs is oh, I can't even remember what she did. She did something bad. What she do, y'all? We didn't watch so many trials. I don't know what she did. I don't know how long we on break. Yeah, Krabby Patty. I can't remember what she do. This ain't the one that did the pew pew and walked away and said that he'd be fine. Did she? Oh, okay. She okay. This the one that stabbed. I can't. She a little stabby. Okay. Oh, this the kiss and kill. This the kiss and kill redrum trial. Okay. I can't remember. They be doing so much. Everybody just doing too much. So I'll keep it up on my screen for Court TV for that. But if y'all want, we can go in here, peek in here, and look at her stuff while they go give old girl some medication, get her blood pressure down, or whatever they need to do. Okay. You say, do they have a bucket by her table? I don't know. Yeah, I think that's the only thing that she could have did was fall all the way out. Like just pass out. Okay. Just while we on break, we won't miss a minute of coverage. I'm not trying to keep us in no well, let me make sure. Okay. Because I believe this is probably why they started court late today because of this. So we'll just watch the Samantha thing in the meantime. I do have it on my back screen, so I will keep an eye on it. And as soon as they go back live in court, we'll go back live because I definitely want to see what's going on. Just like you guys. So we start off with drama with her. Oh, drama queen.
Okay, so that's one. The other one I think is all pictures.
All right, we're going to go on the record on the state of Wisconsin versus Samantha Jean Krebs. The record should reflect this as branch 6 for Outagamie County, state of Wisconsin, Circuit Court. File number is 2024 CF 921. We're set for sentencing on the case involving State versus Samantha Krebs. We'll have the attorneys state their appearances.
Templess and Nick Grody appear on behalf of the state.
Ms. Krebs is appearing in person in custody along with attorney Stephanie Rock. Good morning.
Good morning. All right, procedurally, we're going to start off with some instructions from the court, in particular for those in attendance. This applies not just for the people here in court, but also anybody logged in observing. One of the goals of the court today is to make sure that the hearing is conducted in an efficient way without disruption or interruption. There's serious matters that need to be addressed from both sides, the state and the defense. During the course of their presentations or at any time during this hearing, there should not be any disruptions. Number one, there's a sign on the door indicating that people in the gallery should have their phones off. If you have a phone, you should shut it completely off, not just mute it or put it on vibrate. It needs to be completely off. If you violate the phone rule, either a bailiff who's in the back or one of the deputies will escort you out. So the one warning has just been provided regarding phones and other electronics. During the course of the hearing, the subject matter will be sensitive. And it's reasonable to have an emotional reaction on sensitive topics, such as the one we have in the court today. However, the court cannot have emotional disruptions during the proceedings, whether that's verbal or physical of any type. If you don't believe you can contain your emotions during the course of the hearing, it's best to step out now and find out what happened later on from others that are in attendance. During the course of the matter, the proceedings, the court expects to hear presentations from the state and defense that can include or will likely include statements from people associated with the victim, Mr. Carnot, and maybe even some from people associated with Ms. Krebs. When that's done, the court expects that to be done from a microphone at one of the tables. It's important that anybody addressing the court take their time. If they're going to read a statement, that's okay. Or they can speak directly to the court without reading it. It's appreciated if that person speaks slowly or in deliberate fashion, just so the court reporter can keep up and make an accurate record of the sentencing here today. So at this point, if there's anybody in the back that has a phone on, it needs to be shut off completely. If there's anybody in the back in the gallery that doesn't think he or she can contain that person's emotions, that person should step out now. The time we spent here will likely be in excess of 2, maybe 3 hours. So the court expects to have 1 or 2 breaks during the proceedings. Has the DA's office had a chance to review the pre-sentence report prepared by the Department of Corrections?
Yes.
Is there any edits or corrections?
No.
All right, Attorney Rock, have you and your client had a chance to thoroughly go over the pre-sentence report that's labeled document 404, submitted October 28th of 2025?
Yes, we have.
Any edits or corrections?
On page 10, the very last offense that is listed is a shoplifting offense with the conviction date of 8/3 of 2005. Ms. Krebs has no recollection of that. I was not able to locate that anywhere, and I cross-referenced this with the document that the state had prepared when we were getting ready to argue prior convictions, and I did not see that on there either. So I just wanted to point that out. I'm not sure where that came from. And then on page 11, very similar situation. It's the second to last offense that is listed. It's a shoplifting in Wood County with a conviction date of November 5th, 2003. It's the same scenario for that. Other than that, we have nothing else to note, Your Honor.
Okay, and you and your client are ready to proceed today?
We are.
Is that correct, Ms. Krebs? The court, before attorneys' arguments, will hear presentations. Does the defense expect to present any statements beyond the written ones that were submitted?
No.
All right, and the state gave notice that there was a number of people that wanted to address the court. Is that still the case, Ms. Templis?
It is.
All right.
Your Honor, if I could, with regard to the list that the state submitted, I would just object to the last individual that's listed. I won't state the name for the record at this time, but the initials I can give the court if they want, but it's the last individual. I don't believe that that individual would be a properly identified victim, and would just note that for the record.
All right. Is the last name on that list, Ms. Templis, is that somebody who's a blood relative or associated with the victim that would trigger certain rights under Chapter 950 or Marcy's Law?
It's a former teacher of the victim as well as a family friend. So I believe for purposes of 950, she wouldn't fall under that category, but I still believe that she is able to make a statement to the court.
All right, well, we'll wait till the end for that person. And if there's any citation you or Mr. Grody want to look up for me to consider that, the court's still open-minded about that. All right, who's your first presenter?
If the court can wait just 1 second. I just want to. I did consult with our victim witness coordinator. Laura would be the first person that was going to make a statement, then his family, and it's ending with mom, and mom wants to make the last statement to the court. In my experience and understanding, anybody can make a statement to the court. The written statements that the defense provided include family, friends of the defendant. I don't see this as being any different from that. The only difference is one is written and one is in person. Certainly if they had people who were here who wanted to make statements to the court, I would think it's appropriate if they wanted to speak on behalf of the defendant to have that person make a statement. So I see this as completely the same as that. I think for the court's ruling and sentencing today, I think the court can take any information in. Anyone's free to write a letter to the court, and I certainly think she would fall into that category.
All right, on an overlapping issue, have you had discussions with the media people about who wants to be identified and not identified?
Yes, we have worked it out with them. I'm comfortable with our conversations.
Okay. All right. The court often gets statements in writing and sometimes verbally at sentencing hearings. I don't think there's a strict limitation on that. It's more of a discretionary situation for each court. So the court's going to allow the person named Laura to present her statement. Whatever weight I decide to put on it may be limited, but the court feels it's important for both the state and the defense to be allowed to present some statements, whether in writing or verbally, from people that may not be blood relatives or be under the definition of a victim under Chapter 950 or the Wisconsin Constitution and Marcy's Law. However, since it's just one person beyond the other four family members, the court in its discretion feels it's appropriate to allow, and the person with the first name Laura can come up. Okay. She'd sit at the table with you. Okay, and she can be at the microphone. And for the record, you're Laura Lindberg, is that correct?
Correct.
All right. And as I said to the group in the back, anybody that speaks, take your time. We're not in a hurry. It is important that the young lady to my right, the core reporter, makes an accurate record of everything that happens today. So being deliberate or at a pace that is easily understood would be appreciated, and you can take your time. So go ahead, Ms. Lindberg.
My name is Laura Lindberg, LauraLindberg. Thank you for the opportunity to share my statement. No one will feel the loss of Joey more than his family. He was a beloved son, grandchild, brother, nephew, cousin, uncle, and his most important role as a father. His true friends are left without his kindness, willingness to help out, and infectious laughter. During her trial, Samantha Krebs attempted to focus on a narrative of the darkest chapter of Joey's life. It was a very brief chapter that was orchestrated by her. It is not an accurate depiction of who Joey was. In a very short time, she took him away from everyone who loved him. As one of his former teachers, I want to share with you what our community lost with Joey's senseless death. We lost an inspirational story to share and help out others. Joey was hardworking and caring. He had an innate ability to see the good in others and want to help them find the light, just like he had. Our community lost a valuable contributor due to Samantha's selfish actions. Samantha Krebs has a long criminal history and has been able to manipulate the system to remain free in our community. Her flippant disregard for the law is evident. She shouldn't have even been living in Appleton when she took Joey away from us. It has been concerning to learn about her constant manipulation of others to get what she wants. I implore you to give her the maximum sentence, not just to honor Joey's legacy, but to prevent future victims. No other family should have to endure this kind of pain. I truly believe that appropriate sentences earlier in her criminal career could have prevented this tragedy. Samantha instead perfected a scheme to appear as a victim, when in reality, she is a conniving criminal. It is time to protect our community from Samantha Krebs by giving her the maximum a sentence allowed.
Okay, thank you, Ms. Lindberg. Who's your next presenter?
I was asked to read a statement from his grandmother who has prepared something for me to say today.
Okay, and that's Mary Carnot.
Yes.
Okay, go ahead.
I was asked to give my opinion on what the sentence should be for Samantha. I'm trying to do this without anger. My heart pains every day thinking about Joey. Anger builds up in me. They say that time will heal all wounds, and I pray that someday it will. I don't want this feeling of revenge. The Lord says, vengeance is mine, and I believe it should be in his hands, not mine. Given all the evidence presented during the trial, I feel Samantha should not ever be eligible for parole. I feel she should spend the rest of her life in prison. I just want her to know how she tore up our family with so much heartache.
Thank you for that information from Mary Carnot. Go ahead with your next presenter.
The next presenter will be Joey's sister.
Could we possibly get the screens for this?
Say that again?
Could we possibly have the presentation screens for this statement? This one photos the victim would like to show, as well as some voicemails.
All right, and this is Kayla Vandenbloemer, is that correct?
Yes.
Okay, go ahead when you're ready.
A victim impact statement. What even is that? That's what went through my head when I first received it in the mail. A victim impact statement is a written or oral account from a crime victim describing how the crime impacted them. In this instance, the crime being first-degree intentional homicide. And what exactly is that definition? First-degree intentional homicide is defined as causing the death of another human being with the intent to kill that person or another. Intended to kill is defined as the defendant, Samantha, must have had the mental purpose to take the life of a human being or been aware that their actions were practically certain to cause death. And that human being whose life was taken from him was my big brother, Joseph John Carnett. You stabbed him in his kitchen, stood over him while he was gasping for air, and then you left him to die. You were too worried about yourself. You intentionally killed my brother. You made threats in the past, and you followed through with your threats. He is gone. What does that mean? That means I no longer have a big brother. I can't call him and talk to him about my day, my life, or parenting. When I am needing some advice from my big brother, I can't pick up the phone and call him. He always had an answer for me and knew just how to make me laugh every time we talked. Unfortunately, I no longer have that. You, Samantha, you took that from me. And with that, I'd like to play a voicemail I have from Joey.
Hey, little sis. Just wanted to give you a call, tell you I love you, and just to give you some encouraging words and some loving words from me from the heart. You're an amazing mother, and that boy is he's gonna love you tons, more than you'll ever know. So. I'm sorry if, I woke you up or whatever, you guys are trying to all get to sleep. I don't know. I just wanted to call you and tell you that stuff, And I owe you a lot because you've always been the best sister anyone could ever ask for. So I love you, but I'll let you go. Have a good night. Bye.
This is Joey, full of love and kind words. He always, always said, I love you. Joey did not deserve to die. This is a picture of Joey and Kason. A loving, happy father holding Kason while he naps. Something you, Samantha, you took from my nephew. He won't ever have his dad to hold him ever again. You took the stand and raised your right hand, sworn to tell the truth and nothing but the truth. But did you? You diagnosed Joey as this manic person. Joey was in my life for 31 years, and manic is a word I would not use to describe him. In fact, he was the complete opposite of that. He was the most selfless, caring person you could ever meet. He had the biggest heart and would do anything for anyone. He was always happy. Joey's laugh was contagious. You couldn't be around him and not laugh. He had such a strong faith and relationship with God. We shared our walk with God stories often. I'd like to play another voicemail I have from him.
Just giving you a call, little sis, seeing what you're up to and how you been. And hopefully your walk is going good with God and your faith is still strong. And I love you lots. And just give me a call whenever you get some time. Okay, bye, sis.
Can we play that one more time, please?
Just giving you a call, little sis, seeing what you're up to and how you been. And hopefully your walk is going good with God and your faith is still strong. And I love you lots. And just give me a call whenever you get some time. Okay, bye, sis.
This is Joey with a strong faith, a caring big brother, checking in on his little sister and making sure to tell me he loves me. And with that, I am certain he is in heaven, living his best life. Joey may have fought a battle with addiction, but he was certainly not crazy or whatever other words you were using to describe or diagnose him with. This is a picture of Joey and Casey on the day Kason was born. Joey's life was now complete. Nothing else mattered in this world. Joey was now living to be the best father. Kason was his number one. Kason no longer has a dad, and he is often wondering where his dad is. I don't know how to respond to these things. I feel so lost not knowing how to comfort my nephew. Seeing Kason struggling with the loss of his father, and I don't know how to help him. How do I explain this to him? What am I supposed to say? All of his school and sporting events, he won't have his dad there. How am I supposed to comfort him while he's looking in the crowd for his dad? He doesn't have his dad there to tell him everything is going to be okay when he just needs that father figure to lean on. This breaks my heart. I wish I could bring Joey back, but I can't. I'm not sure if you're familiar with Build-A-Bear, but it's a fun place to bring kids to pick out a stuffed animal and stuff it, dress it, and name it. This experience was not like that for us. When it was time for Kason to pick out a heart to stuff his dog with and make a wish, he wished he could talk to his dad again because he is dead. My stomach was just in knots and my heart shattered all over again. This is just one of many uncomfortable situations that happen in public. People start asking questions and expressing their sorrow. It's a feeling of social awkwardness for all parties. This past weekend, my son and Kason were playing pretend, is what Kason would call it. And he was playing pretend that my son's father is dead. Someone killed your dad, and we need to find out who did it. This is what I would call trauma. Trauma that Kason has to live with for the rest of his life because someone, Samantha, murdered his daddy. My 3-year-old asking, "Mommy, why are you sad? Where is Kason's daddy? What is heaven?" How do I explain these things to my 3-year-old? He doesn't understand what's going on. This has had such a negative impact on my mental and physical health. For months, I could not sleep through the night, which affected my day-to-day life. I have been through and continue to go through hours and hours of therapy. Mentally, I now have to live with the trauma of all of this. I will never forget the phone call I received from my mom telling me Joey passed away last night. When I got that call, I was in a balloon store ordering balloons for my son's second birthday party. Planning his birthday parties will never be the same, nor will walking into that balloon store that I go to regularly for planning all our parties. For the longest time, I couldn't pick up a knife, which meant no cooking meals for myself or my son. I barely ate for months, and at home, my son ate food that was quick and easy. Clearly, I was not healthy for quite some time, which also impacted me being a present mother. I struggled to be attentive to all of his needs. This has affected my work life as I am not able to perform my job 100%. I have missed so much work. I am grateful my employer has been understanding with all of this. Triggers and trauma I have to live with for the rest of my life. Saying goodbye to my brother's dead body at the funeral home. His cold, stiff body and long incision along his hairline from his autopsy. This is something I was not prepared for, nor was I prepared for picking out pictures and songs and planning my big brother's funeral. Next, I'd like to play a video of one of the few picture boards I put together.
Yeah, I believe I'm when to say you're in a better place. You had a wild side, but you had amazing grace. I know you're way off up in the clouds, but if you could still hear me.
I have to somehow pull myself together. Things that I will never be able to erase from my head Like the day my family and I read the criminal complaint, to hearing and seeing things on the news about this case and thinking to myself, I can't believe this is real life. I just kept thinking I need to wake up from this living hellish nightmare. Then sitting through my brother's murder trial and the flashbacks from it. The flashbacks that will never go away. Joy will never walk through the doors at another holiday gathering or be there for Kaysen's celebrations. Pre-trial was on Halloween last year, and hearing those things in that moment will never leave my mind, making future Halloween years never be the same. Thanksgiving is Thursday, and as we sit around our table to eat, we will be missing Joey. Nothing will ever be the same again. Not ever. Where do I fit in my family now? How many brothers do I have? Am I now considered the oldest? Do I say I have a big brother? What do I say to people? These are uncomfortable conversations for me. I'd like to go over Joey before Sam, Samantha, and after Samantha. This is a picture of Joey and Kaysen at altitude playing on a Saturday afternoon. Joey was clean cut. He was happy. He was involved with Kaysen. Before Samantha, he was shaved, clean cut. He cared about his appearance. He was very organized, picky. He went to the gym frequently. He ate healthy. He was involved with family and a few close friends. He was going to church. He was involved with Bible studies. He was great and involved father, brother, and son. He enjoyed boating. He was even running. He was active. He enjoyed rollerblading, going for walks, the little things. Next, I'd like to play a video of his apartment when he first moved in.
Kayla, I finally made my first meal, and it is going to be amazing. All by myself, but you know, it is what it is. I got some nice things to hang up. You know, I mean, I don't know. I'm just trying to live life. That's just Kaysen's room. I got him a picture. Mom bought him a picture for the top of his crib. It's gonna be beautiful. I don't know. Just wanted to give you a heads up on what's going on here. I love you, sis.
Joey was so proud. His apartment was clean. There was no clutter. And he made sure to end that with, all right, love you, sis. This is a picture of Joey and my grandma putting up his Christmas tree. He was involved with family. And this Christmas tree is in that same apartment that he was murdered in. He wanted to have a nice Christmas for Kaysen. He cared. Joey's heart was so full. He loved family time. He was involved father. He was an involved, loving father. Kaysen no longer has his father to put his toys together for him. He will never have that one-on-one time again with his dad. You, Samantha, you took that from Kaysen. After he met her, he was using drugs and vaping. He looked dirty. There was clutter everywhere in that apartment, as we all seen from trial. He stopped going to the gym. He cut off family and friends. He stopped going to church. He was not involved in any Bible studies. And towards the end, he didn't even see Kaysen. I saw a picture of him towards the end, and he had a nose piercing in his nose, and like she had, and he had rings on his fingers. That I didn't even recognize him. I didn't even know who that was. This is a memorial picture. This is a stone from the VA in honor of Joey. It reads as follows: Joseph John Carnett, beloved father, son, brother, National Guard, U.S. Army, August 2008 to November 2010, 2nd Battalion, 127th Infantry, always in our hearts. We all make mistakes in life, and I am a firm believer at giving everyone a second chance and even a third chance. Samantha has had too many second and third chances. She has had too many opportunities to turn her life around for the better. She is a 40-year-old grown adult and knows right from wrong. She is a cold-hearted manipulator. I strongly believe she should be in prison for the rest of her life without parole. Samantha should never be granted her freedom to go out and kill again.
Okay, thank you.
Okay, so our original case that we are looking at today with Sandra, they are back. I just wanted to kind of get us a good stopping point, so I didn't stop dead in the center of her testimony. So let me go ahead and get us back into the courtroom live, and let's see what they got going on. Is all I can say. Maybe they come back and say her head still hurt. Who knows?
People versus Shanda Vander Ark. All right. Mr. Ambrose, did your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on between
Yeah.
the deal and
The MDOC is the one that would dispense it, since my understanding, because she's not in Muskegon County custody, that it have to go through MDOC. So I did send an email to the person in charge of the MDOC, who would be the person that could authorize at least some medication.
how is her headache now?
Not good. I mean,
all right. All right. I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record.
Stipulate to any sort of protective order that the defense would want.
Mr. Ambrose is
that's fine.
okay. So I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, looks like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent, and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness, and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness, because there's no record of that in the prison. So anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, she would have to report to the medical personnel that she actually did lose consciousness. So
Well, I mean, okay, I get it, but the quote is, quote, "I felt like I was going to pass out. I have tremors that are severe." That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling or lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, why don't I get into that? Says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So, so based on that, I don't see a serious medical issue that is to the concern of the court. So anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through. That's fine. But if the request is for an adjournment because of a medical issue, I don't see it. So. I'm not, listen, I'm not going to delay this anymore. This is, in my opinion, Mr. Ambrose, she's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock on a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go. So, okay. Anything else? No. Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yeah.
Man, guys, now I gotta take it to trial. Is gonna have to do a passing out class, because right now she's supposed to do it for the gram. Like, she was just supposed to fall all the way out. Like, you think I'm playing? And just fall out. Like, she don't know what to do. Like, these people don't know. We're gonna have to do a take it to trial falling out class. We already got the cry class. Now we're gonna have to start building people for the. I mean, like when he said she misrepresented, she should have just fell out and started shaking like I'm having a seizure up in this bitch. Like, you know, she's sitting over there clapping out with that mouth. That mouth, I wish she had a mic. Mic her up, because I want to know what you got to say, because she clapping back with that mouth right there. And I'm like, you doing all this? Do it for the gram. Do it for some content. Just pass out. Judge, you don't know what you talking about. Boom. What is going on here? Boy, this lady here, she is hot. Like, why does she keep trying to delay this mess? The judge, like, you have misrepresentative. You out here playing everybody. And she was supposed to make it real. Like, stand on business today. Like, you don't believe me? You have really worked. My anxiety is through the roof and I am passing out. That's what come on. That's what I'm saying, Rachel. It's her appeal. So she should want, if she's saying that everything is everything, then we should be just doing this at this point in time so we can get a new trial. Take that shit to trial. Like, we taking it to trial, right? That's what you want. You want a new trial. Okay, so I am going to be working on a curriculum for the passing out class, because apparently we got to tell people when to pass out, because I'm sitting over here yelling in the background, please pass out. The judge said you phony, make it real, put it on the record. Good grief. Here we go. She looked totally different. She look a hot mess. I see she ain't trying to wear them all. When she had these little ponytails, y'all, this look, I don't know why. I guess maybe she wanted them to think that she was a kid or something. Like, this looked like almost like corn star activity or something. These braids at this age, like what the fuck? Oh, gosh. All right, let me take. I'm glad she looking just her age right here, old and scrubbly. Like we ain't got time for that. Here we go, y'all.
You can call your any opening statements on either side, or you want to just go straight into witnesses?
We can go straight into it.
All right, you can call your first witness. All right, Mr. Johnson, if you want to come on up front here, sir. Good morning.
Good morning.
All right, would you raise your right hand to be sworn?
Yes, sir.
This matter now pending. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, FredJohnson.
Mr. Ambrose, you're welcome to stay at the table or the podium, whichever you prefer. So you can stay standing, stay sitting. It's up to you, okay?
Thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney?
Yes, sir.
Can you tell us when you became an attorney?
1984.
And I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information. You understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some confidences.
Yes.
Are you okay with that?
Yes, sir.
Do you have any questions regarding that?
No, sir.
Okay. With that disclosure, Your Honor, I'm going to proceed with.
Okay. Anything else we should put on the record regarding that you want, Ms. Bloomquist? Okay. All right. Good enough.
What year did you become an attorney?
1984.
Okay. And where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced criminal law, yes.
Okay. And has your license, have you continuously been an attorney ever since 1984?
No, sir. My license was suspended last year for 6 months.
And what was that? So it was suspended last year for 6. What was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay. And that was while you were a public defender?
Yes.
And when you represented Ms. Vander Ark, you were a public defender. Is that true as well?
Yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was, I couldn't tell the year, 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay. And
2023, perhaps.
Did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013,
And
September.
what did your office consist of?
In 2013,
Throughout the years.
it grew over the years.
Okay.
We started, I think we're at 13, and by the time I left, we're in our 20s, maybe 25, 26.
Okay.
And that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance.
Yes, sir.
And what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I didn't. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay. And did you testify at any of these hearings?
Which hearings? The ethical issues hearings?
Yes.
Yeah. I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar. I think that was under oath as well, so that both might be considered testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
And would you disagree with, I was working too long, I was working too many cases, too much stuff, too many irons in the fire? Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
Also, basically, when I was a public defender, I was working on a conveyor belt system. And the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned?
When I was public defenders?
Yes.
Okay. The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally that was the situation, unless something came up and then we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the year. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion there are, and there were.
Upon receiving the assignment, do you recall when you would have first talked to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
She testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned on to the case, did you have Ms. Vander Ark see a professional with regard to competency or criminal responsibility?
I had Ms. Vander Ark see several professionals, 2 doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversations we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall that specifically. If you have the report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, as what I recall.
May I approach the you may.
Here. Yes, sir.
And it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial as she's charged with first-degree murder. But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
None that I can recall, Your Honor, sir.
Now, Ms. Vander Ark testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That is correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son.
I believe that was if we're talking about the situation where she turned and there was a trash can there and she She appeared to, I don't know if she actually did vomit, but she had, the body language was indicating that's what was going on. I was sitting in the chair over there where the prosecutor is.
And during her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you see Ms. Vander Ark after court that day?
Ooh. I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
The next day, can you tell us what happens?
And if my recollection is correct, the next day, court was resumed, and my client, Ms. Vander Ark, was unable to attend. She was unable to come to the hearing, as I recall.
And you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point. Is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and yes, sir.
May I approach you again here? And this is, I'm showing you a transcript of December 15th, 2023. It's on page 3. If you can just read that portion.
Yes, sir.
And so you indicated to the court that she wasn't competent to proceed, is that right?
That is the word I use, sir.
Okay. And describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying. She was upset. She expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She's experiencing a period of where she's so emotional she can't function intellectually.
And based upon that, you reported that to the court.
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing with that. I assume you have transcripts there. I don't recall saying that, but.
If you look on page 4.
Which paragraph, sir?
The second full paragraph.
Okay.
Starting with the word 1.
Okay.
And you agree that you told the court we couldn't guarantee to the court that as of Monday or Tuesday or even Wednesday of next week, we'd be in any different situation than we are right now.
That is what I said.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
Do you, okay, so one of the things that you argued to the, or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter.
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me which page?
Yes. I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes. In the back.
Okay. And whereabouts on 84, Council?
It's actually on the very last page, page 80.
All right.
First full paragraph. And you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
Yes, sir.
They caused the boy's death. That's
Yes,
what
sir.
you said. Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
I have nothing further.
Morning, Mr. Johnson. How are you?
I'm well, thank you.
So I'm just going to go back a little bit more into your experience. How many years have you been a practicing attorney?
41 this year.
And how many years of that as the chief public defender for Muskegon County?
2013 to 2024, so 11 years.
Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Okay.
Yes, ma'am. My apologies. I'm on the roll here.
Now, just sort of getting into some of the comments that were brought out from your sworn statement or things like that. There's discussions about your workload. Do you recall that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of the group of a pack, and we place not only my efforts, but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information and I shouldn't have seen it. It impacted there. That's what I think has happened. So, but I'm sorry, go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between, Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And, while we're on that topic, did you have to sit in that exact same witness chair and again, they're hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim.
Okay.
Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pour over it. You go out and see your client, you talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues back by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney in to sit in this, to watch the whole process. We also employed interns here. So the beauty of interns is, whereas I may have multiple cases, they only have the one, and they pour over the documents and the materials. And if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Vander Ark. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Miss Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going, over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3 social workers, so we're up to 9, and a half a dozen interns, so about 15, 16, something around that line.
So 15 or 16 people working on her case specifically.
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe to the court your preparation for trial?
Well, at this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering experts, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman who'd thrown her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And quite frankly, I'm still convinced there's something to do with my client's conduct. But it was hundreds of hours by then. And I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I've told her I think if she had to hire, she'd spend $1 million on what we did for her in terms of trying to prepare and defend her in this case.
So just so I'm clear, you yourself dedicated hundreds of hours
Yes, ma'am.
personally to this case.
Yes, ma'am. It was either I'm reading something or I'm talking to somebody. I'm looking for this needle in the haystack. I believe then, and I believe now, there's something wrong with my client, and that there's somebody out there who would be able to tell me what it was. And I still believe that to this day.
So I want to dive a little bit deeper. You said that you sought out experts, correct?
Yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run?
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which ones to approach. We also use here from the other lawyers in the office. Have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
Okay. And so I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
And did you also get a report from a George Watson Jr.?
Yes.
Okay, and to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients. They would have been prosecution witnesses if we presented their findings.
So you intentionally did not call these experts?
That is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, "She's a monster." His response was, "She's the worst thing he'd ever seen." And he's a man who testified for mass murders. I did not want to bring his testimony in. Dr. King simply said that she was competent at the time and she was competent for trial, and and that's not what I wanted the jury to hear. I want the jury to hear that there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for him. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. The two, and it probably is just because that's the way I'm built. I just can't believe that a healthy person would have done the things that she did. I don't believe it to this day.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in fact, do that?
Yes, ma'am. The evidence? Yes.
And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation?
Of my client?
Of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she's going to testify and the sorts of things she might be asked and the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions
Yes.
on this case?
Certainly. And that was the value of the groupthink. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take it to the Court of Appeals if we lose, that sort of thing? All those issues were discussed.
Did you also prepare for your voir dire in this case?
Yes, I did.
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes,
Okay, and in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Your Honor, would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency unless someone's pre-marked exhibits, but we'll do numbers.
Okay, I'm going to be showing, may I approach?
You may.
All right, I'm showing the witness what's been marked as People's Proposed Exhibit 1. Could you identify what this is for the record?
Yes, this is my standard voir dire sheet, in which 4 pages of questions that I may or may not be asking depending on the nature of the case. But certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial or?
Yes, I did.
Your Honor, at this point in time, I'd move for the admission of People's Exhibit 1.
Mr. Ambrose?
I'm sorry.
He's been moving for admission.
Oh, I have no objection.
Okay. All right, so Exhibit 1 is
We can
admitted
just leave that.
without objection.
What did you do to prepare for voir dire? Was it all contained in this document or what else did you do?
No, ma'am. The day before, a couple days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information. It used to be better when it was handwritten, but now the computer stuff is not as helpful. But there is information, and we, and I say myself and the interns go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on there, and so we're going over these things and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people, witness? Are they friendly to us? Would they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list that they gave us as to individuals we may not be called, we may not wish to sit on the jury. A police officer. If there's a police officer, we're probably going to ask him to be removed or her to be removed. So we go over that. Then when we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and would you answer any different? So you can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions, and they kind of help keep the interest of the rest of the panel. So that is part of the voir dire preparation. The reality with voir dire is, if you pick a bad jury, the case is over. You're done. You've gotta emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client. So we put a lot of emphasis on it.
And you specifically did in this case.
I specifically did in this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial, how many jury trials you have conducted?
Misdemeanor, oh gosh, misdemeanor and felony, maybe 2 or 3 a year, felonies. And back when before I became a public defender, 10 or 15 misdemeanor cases, literally a couple hundred. I don't know. I've lost track a long time ago.
You don't keep a sheet with them?
Yeah, at least 10, 15 a year for 30 years. So.
Thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel, and I tell my folks, the young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions when my voir dire may be brief, but hopefully it's effective. And I'm talking, and as Judge Casey will tell you, I talk loud. Everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people out the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. Sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's going to do what we want. I want a jury that's going to say not guilty. I got a jury as close to that as I was going to get from this panel.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her. Well, okay, me personally. Gosh. No, it was, I tried to get her at least every other month. So if we had a year, maybe 6 times, maybe. And then during trial, gosh, and then after trial, and then are you counting the time after trial when I went to Jackson to meet with her?
Well, let's
Or just before trial?
let's say before trial.
Okay.
Then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well, notwithstanding what she was convicted of. Ms. Vander Ark was a wonderful client. She was a client from heaven. We talked. Her conversations were on point. She used time well. She didn't keep me after the point of the visit was over. She asked good questions. She responded well. We had and we have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative
Oh,
client.
absolutely, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She missed one question on her bar examination. She clerked for 2 judges. She must have sat in on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She could understand and put together the facts and circumstances in a way that a layperson couldn't do, and that was very effective for her and very and I appreciated it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there is something mentally wrong with the person that committed this offense. Quite frankly, as I would tell my folks when I first met her, and in the first 6-7 months we worked on this, I would tell them there must be somebody else living in that head along with her, because the person I knew and the person who did these things, they just didn't matter. So our hope was to find somebody who could put a finger. This is what she has. This was what's wrong with her. When that proved to be didn't bear fruit, we moved to, okay, when did she perform? When did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in second degree, all the all the homicide crimes, we discussed each and every one of them.
And you read portions of your closing argument.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody hasn't been attention that something wrong has happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up but I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them, this is what's going on, and I'm not going to try to lie to you or put a lawyer tricks and fool you. If the glove don't fit it, you must have quit that stuff. I'm an honest guy. This is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you in your closing argument, given her mental or physical state in the jail?
We had before the day that morning, we had stopped talking about what we were doing in court, and it was just a conversation of, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during the course of my representation of her. But the reality is a closing argument is as much art form as in science. I don't know exactly what I'm going to say every time. So I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify, though, your decision to concede manslaughter wasn't an off-the-cuff decision.
Oh, no, it was not. No, it was not.
And you conducted some investigation and you put a lot of thought into doing that, correct?
Yes.
Okay. So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 a year, so 30 or 40.
Okay. And so have you had situations where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes.
Was that the case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to she was in Judge Casel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes and slide them over to me.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand. When trial was over, did I go into the jail? Okay.
Thank you for clarifying. That was a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded her cross-examination,
Yes.
When that day concluded, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day myself and the social worker involved, we go back and we talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her after she walked out of the court that day. Then I don't recall.
Okay. So let's move into that Friday morning.
Yes,
That
ma'am.
you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
My Ms. Vander Ark and my caseworker. Who's my caseworker? My social worker was there. I'm trying to remember which one it was. Give me a minute. I don't remember which one it
Would
was.
it be Melinda Katecki?
Yes, yes, that was Melinda.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell with us. There's a cell area and they stand outside of that. They weren't in the cell with us.
Okay, so to your recollection, it was you, Ms. Katecki, and your client.
That's my recollection.
Okay. And you indicated that she was on the ground, curled up.
She was on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her? Like at the start of that morning, when you first walk
Okay.
in, what's the conversation?
Are you okay? What's going on? Can I get you something? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Kotecki was also talking to her, the same sorts of questions. What's wrong?
And what did Ms. Vander Ark reply?
Effectively, I can't quote her, is what she said. Her response was that she could no longer, she could not go up into the courtroom today. She couldn't take the trial today. She was having an episode and she just couldn't tolerate being in the courtroom today.
And at some point you come up to the trial court and you place on the record
Yes.
what occurred, correct?
Yes.
And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes.
Did you in fact discuss her options on how to proceed that morning?
Yes. Yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back into court and just sit there. We're not going to put you on the stand again today. Just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing. So so that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available, I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to refuse to come to court.
If she signed an affidavit saying that she is voluntarily choosing not to come to
Oh,
court, would that
yeah.
refresh your recollection?
It does. You're correct.
Okay.
Counsel, that she did sign an affidavit to that effect.
Okay. And did you know that was happening, or were you aware that was something that was being drafted for her to
Yes,
sign?
yes, I was.
Okay. And so does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her her ability to waive her presence?
Yes, I remember in the context of the affidavit. I think we came up and came downstairs a couple times. And when we came down and said, this is what's going to happen, you have this, if you don't want to be there, you have to let us know. And she signed an affidavit to that effect.
Did you coerce her in any way not to come to court?
No, ma'am.
Okay. Did you want her to come to court?
Yes, ma'am.
Would that have been better for your case if she came to court?
It would have been better. Yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit?
Yes, ma'am.
Or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was on page 3 of that transcript you have there, you said, well, that's the word I used. Could you explain your response to that question?
That what I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean it. I meant it as a layman would use the word competent. She just wasn't ready to go. She wasn't able to write me those notes or to whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I was going to say competent again, to participate in the process. This is her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had episodes before, correct?
In my presence, she'd had, if we're not talking about when she saw the photograph, in my presence, she'd had one episode, but she expressed to me during the course of our representation that she'd had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the prelim.
Okay. And the record will speak for itself about
Yes,
when?
ma'am.
Okay. Shifting gears a little bit. Now, it wasn't your strategy to discuss hydration in depth, was it?
Was it my
Dehydration and
No, ma'am.
why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with the deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration or she injured him by starving him or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
So that was a conscientious choice on your part.
Sure, and we weren't arguing that the boy was dehydrated. We weren't arguing that he had passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy. And nobody's going to take a look at those pictures and say, this boy needed water.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The best thing I did in that trial was the best thing that happened in that trial was the fact that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our clients than showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I die, that was the right strategy. It's the best thing we did during trial was keeping that video out. It's just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers
My position was that the video was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close on. It's just it was, and given the weight of all the other information that Mr. Roberts had presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it. We use this description, but we wouldn't use the actual video.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay.
Oh, no, ma'am. That was a relief.
I can just have one. Thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Ambrose. Any follow-up?
You mentioned that the morning of December 15th, 2023, Ms. Vander Ark was on the floor, curled up.
That's the day when she she declined to come to court? Is that what you're talking about, counsel?
Yes.
Yes, sir. That's how I found her.
And you did you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor.
Okay.
And I believe they did speak to me.
Do you recall telling, when asked a question about your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state?
I may have used that term, yes.
And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than what I report to the court. And that's what I report to the media.
You know, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it? Yes, sir. The trial, would you like me to elaborate? The
Yeah,
answer to your
go
question,
ahead.
yes. Okay. The trial strategy was not to try to explain that there was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome. Does that?
Was there, to your understanding, was there any restriction on water
For
Timothy?
No, not that.
And when's the last time you saw the death certificate?
I would have seen it before trial. That would have been the last time anyway.
May I approach the witness? You may. All right. This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate of the victim in this matter.
Okay, and what's the first thing that's listed
Located.
as being the cause of death?
Okay. Cremation. What box is that in? Do you know, Ralph?
36.
Okay, I was looking to that.
Near the bottom.
Okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration would be lack of fluids, right?
Yes, as far as I know.
And like you said, there was no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
All right, I have nothing for you.
Just ask a brief follow-up. So, Mr. Johnson, if you had focused on dehydration, would that open avenues to the prosecution to enhance some of their arguments?
I would assume.
Such as the fact that he didn't have access to water when he was locked in a closet, correct?
I didn't want to get into that.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I would assume that's at the end. I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause the death, I opened the door for Mr. Roberts to show that, okay, it did. And that this wasn't an issue. And I didn't want the jury to hear more of that. I want them to hear that my client just didn't get it. That was the message.
Thank you.
Any follow-up to that, Mr. Ambrose?
No, Your Honor. Thank
Okay. Mr. Johnson?
Sir.
I have some, well, it's a noon hour. Are you available this afternoon, Mr. Johnson?
Yes, sir.
All right. Let's break. We're going to, since we lost some time this morning, I'm going to have us return at 1 o'clock after lunch. And then we'll resume. Mr. Johnson, you can stand down for now. I would like you back at 1 o'clock.
Yes, sir.
Anything before we break, Mr. Ambrose?
No, Your Honor. Thank you.
Ms. Bloomquist.
No, Your Honor.
All right, we are in recess for lunch. Thank you.
Yeah, go give my girl some Tylenol, some medication. Let's get something together. Oh boy. So they said they'd be back at 1. Yeah, go get my girls. How long is that? Let's see. 11. Oh, okay. So that's about 42 minutes, y'all. So that's not bad. We want to go back into her testimony, or do we want to we got a couple things. We can either go back into her testimony, or we can go back to Samantha Krebs sentencing, and I could maybe play that on 1.5. No. Oh gosh. Oh gosh. The sentencing. She look like a thug. I don't know. She look like she got some gangsta up in her. Gangsta up in her. She walking with a little swag up in there. Boy, oh boy, oh boy. So let's share this. Okay, and do y'all think that they gonna get done with this today? I don't know why I feel like they're not gonna get done with this today. I don't know. I just feel like they're not gonna get done. But that's okay. So we got about 40 minutes for break. I don't think the judge is gonna be playing around with them coming back because they lost so much time earlier. So I don't think he's gonna be playing around with that part of it. Like he gonna want them back at 1. They starting back at 1. But here we go.
Ms. Vanden Bloomer, and
The next one will be Joey's mom.
she can come up. Okay, and you can take your time. And just for the record, Cheryl, how do you say your last name?
Swaninson.
All right, go ahead when you're ready.
Joseph John Carnett, born to life 10/26/1988, put to death 7/18/2024, intentionally, violently murdered by Samantha J. Krebs. This letter is a mix of my scattered thoughts, which is just how my life is now. Broken pieces everywhere that I'm always trying to pick up and put back together. Because of you, Samantha, I'll never be able to give my son a hug again. Smell his cologne, look into his beautiful eyes, hear him laugh and laugh with him. Hear him tell me he loves me. Every celebration will never be the same. There will always be a part missing that is our Joey. Every day, I long just to hear his voice and have him call me Mom. Your actions have left a wound that doesn't heal in my heart. The heartache just doesn't go away. I have dreams about him only to wake up and realize that he's not here with us anymore. My heart breaks over and over again. Every time Kason tells me he misses his daddy and tells me I love my daddy, the pain you have caused for his sister Kayla, his two brothers Levi and Kyle, his grandma, Brittany, Kason, and other family and friends. Because I'm Joy's mom, I carry everyone's pain and emotions. It's exhausting. My nervous system is shot. I'm apprehensive and untrusting, waiting for the next trauma in my life. All I could do prior to this, today, this sentencing, is worry for like the last 3 weeks that hopefully I wake up and I don't have a spell of vertigo or that I'm dizzy, because lots of days that's how I wake up. Physically, I have developed high blood pressure and a slew of doctor bills with that. Also chiropractor bills and prescription costs. My vertigo spells come more often. I have repeated spells that I'm standing on shaking ground, a very insecure, unstable feeling. My scheduled time off is meant for vacation, family, and leisure time, not spending this time in court. Joey's death is devastating, a trauma. Sometimes I just want to hide in my yard to avoid questions about Joey. I avoid certain social gatherings. This has escalated my social anxiety. Sometimes I'm present while I'm working, and there are times when I'm not. I'm very lucky that my employer has given me off so much time and has been so understanding, along with all of my coworkers who have been there to hold me up and support me and love me and pray for me. All my friends that have been there for me, all the family, it's been such a loving circle of support. All my counseling sessions, I'd much rather be doing something enjoyable than processing my son's death. So, sorry. These precious, priceless pictures are all I have left of my son. A loving son, grandson, father, brother, nephew, cousin, and friend. So the picture on the left is a picture that I saw. It was almost 10 o'clock on July 18th. And I was just getting ready to go to bed. And as I was walking into our bedroom to go to bed, a picture flashed before me, and it was this picture. And I just got a really warm feeling, and it was a happy feeling because I'd been very worried about Joey in the last prior 3 months. He was on a downslide. We weren't in contact anymore, and the downslide just continued when he met Sam. So at this point, we were at no contact, and I would call, and Samantha would never let me talk to Joey. She screened the calls. So I got this warm feeling. Well, then the next day when I was working, the officers came into Capitol. I had no idea why they were there. And they seemed so serious, and it just concerned me. And my supervisor had asked me if I could take a moment and speak with the officers in the conference room. And I said, sure. And then I just was apprehensive. I walked in there, and then they told me that Joey, they eventually told me that Joey was found in his apartment deceased the night before. And all I could do is just have this picture flash in my head again. And all I could say is, my baby, my baby, my baby, my baby. And I know I was taking Joey home in this picture. God blessed me with Joey. And that's why I saw this picture flash in my head, because God was letting me know that he took Joey home. So he took him back home. I took him home from the hospital, and he took him back to peace. Yeah, he could. This photo is one of my favorites. I took this picture in the winter of 2023. Joey and Kason were sledding. Joey was happy, healthy, and so full of life. Kason was snuggled close and safe into his daddy on the sled, and they were both so full of joy. Kason was the center of Joey's world. His love for his son was overwhelming. Kason, his boy. This picture changed when Joey met Sam. Sam controlled all our visits with Joey and Kason. She screened his phone calls. She would always say he was sleeping. Joey began to isolate more and more from us. Soon Joey's apartment turned from being cozy, warm, neat, and tidy, the home Joey provided for Kason that he was so proud of, turned into a disorganized mess. Little by little, Sam took over his whole life. It was so heartbreaking to see my son, as I knew him, disappear little by little as each month passed by. She filled his apartment with suffocating clutter and strange decor, such as a collection of booze bottles on the top of Joey's kitchen cupboards. Each time we would visit, there would be less and less space to walk and sit, less oxygen to breathe inside that apartment, until Samantha finally sucked all the life out of that space and all the life out of Joey. On July 18th, 2024. Because of Sam's violence, Kaysen's life will never be the same. My heart breaks over and over again. Every time he asks me why his daddy had to go to heaven, why can't I talk to my daddy? In July, we were at Build-A-Bear, and part of the process is to fill the stuffed animal with stuffing and also a heart. Then before the heart is placed inside the body of the toy, the children are asked to make a wish. Well, Kaysen pressed his little hands together to make his wish, and as he prayed, he said, "I wish I could talk to my daddy again." That crushed my heart. My heart breaks for Brittany. She will never have, my heart breaks for Brittany. She will have to take on all Kaysen's heartache and pain while she is still trying to process her own grief. I am a Christian, and it says in the Bible, we are to pray for our enemies. Samantha, I do pray for you. I pray that you will spend the rest of your life behind bars, regretting what you did to Joey. And even if it takes till your last dying breath, you finally admit to killing my son, my sweet Joseph, and you ask for forgiveness for the cold, heartless act of violence you inflicted on my son, that God would have mercy on you and you would be saved. It is my duty to use my voice to make sure you stay locked up for the rest of your life. Evidence showed prior to Joey's death, you at least twice made threats to stab him. Evidence also showed that you coldly, callously made a joke about it by saying, "Well, doesn't everybody at some time want to stab their boyfriend?" And then you cackled. Samantha, how dare you make a joke about the deathly, bloody violence you inflicted on my son and our family. I will also pray for myself that God will continue to carry me through the nightmare that never really ends, and continue to pray and say thanks for all of the love and support I have been given from all my family and friends. Something you may not know, Samantha, is that I'm the one who scrubbed the blood from Joey's kitchen floor. Yes, Samantha, the floor where you violently stabbed my beautiful son, Joseph. And for that, dear, oh dear Samantha, I hope you rot behind bars. I have repeated nightmares about that bloody crime scene. It races in my head day and night. Dear, oh dear Samantha, I hope that crime scene haunts you for the rest of your locked up life. As we approached each court hearing, my body would stiffen up. My sleep was interrupted. My body ached, my head pounded, my mind would race, and my emotions flared. Then there was the trial, which was much, much more. It was like labor pains, so intense, so devastating. My stomach was turned inside out. Every bone, every joint in my body hurt. My head was pounding, my chest was heavy, my heart was breaking. My breathing was labored at times. I was so cold. My vision at times was cloudy from crying. The hardest part was swallowing every emotion into a big, tight knot in the pit of my stomach. Emotions could not be showed. The most important thing was to not distract the jurors and the court. That stress made my heart feel like it was going to burst. Jason's feelings will be hurt, and his heart will break over and over again throughout his life. His daddy won't be at any sport practices, church events, birthdays, graduations, holidays, just to name a few. I can picture his sad face looking out at every crowd where these events take place. Maybe, just maybe, hoping someone out there would resemble or look like his dad. It's such a heavy sadness. His daddy won't be there to tell him everything is going to be okay, or tell him how proud he is of him, or how happy he makes him, or help him with his homework, talk sports with him, or ask advice about friends or girlfriends, decorate the Christmas tree with him, hear his daddy sing happy birthday to him, tickle him, giggle him, snuggle him. When we lost Joey, Kason and I would look out at the night sky to look for the brightest shining star, which was his daddy. Recently, Kason has corrected me on this, and he tells me, Grandma, God is the shining star at night, and Daddy is the sun rising every day. Dear Samantha, what a shame, what a pathetic shame it is because of your cruel, violent action. That's all Kason has to remember his daddy. And dear, oh dear, sweet Samantha, what a pathetic shame it is going to be while you spend the rest of your pathetic life behind bars. My wish for you, dear Samantha, is that every day you hear Kason's words in your head and every night they haunt you in your dreams. Nightmares haunted me before, during, and after the trial. My nightmares is as follows. I see before me an empty, large glass fish tank filled with crisp, clear, blue water. The water in the right corner becomes slightly tainted by black ink. Slowly, the black ink moves to the left and continues to contaminate the beautiful blue water until eventually the black ink takes over the entire color of the water tank. Each time I listen to the 911 call throughout the trial, in my heart and in my mind, my son died over and over again. Each time I heard it, I could pick up more details. The last time I heard it while my sweet Joey laid on the floor, struggling to breathe, dying, abandoned by you, Sam. I heard Joseph's death rattle. My heart shattered. I hope every night of the rest of your sad little life you are restless. I hope you are awakened by the feeling that you are trying to get up because you are in shock and disbelief that you have just been stabbed and that you are choking and struggling to breathe, gasping for air, not knowing if it's the last breath you'll ever take, and have the heartache of all whom you'll leave behind, your child, family, and friends, and to have someone standing over you just watching you struggle, watching you die, and that person is someone you trusted. And for that, dear sweet Samantha, I hope you rot in prison for the rest of your life, for the agonizing pain you have caused for me and my family. Evidence showed Samantha tormented Joey by continuing to use in his apartment. She was cruel beyond words. She showed no consideration for Joey's substance abuse cravings. She played with Joey's mind and emotions. She preyed on Joey's good-natured, generous, gentle, loving heart. Samantha, how dare you torture my son like that? Sam, you continued to isolate Joey from his loving family. Then you manipulated his heart and mind and filled his head with lies. You turned him against us, his loving, loyal family. You filled his house with drugs and replaced us with your so-called good friends, better known as your accomplices, John Pfeffer and Jeff Hayes. Samantha, how dare you tear apart our family like that? Joey struggled with substance abuse at different times in his life, but this time was different. He just couldn't get out from under the control of Sam. She made her final statement to enforce her power and control as she coldly stood over the top of him as he took his final breaths. For this, Samantha, oh dear Samantha, every day, I hope you spend every day of your life in prison in misery. When John Pfeffer wanted to call an ambulance, Sam stated, "Wait," while the last 10 minutes of Joey's life ticked away. Joey will be missed dearly by all who loved him, including his loving family, Kason, Brittany, aunts, uncles, cousins, friends, and the community. Joey loves sports, movies, boating, or bonding over a home-cooked meal. Above all else, Joey's proudest accomplishments were centered around his role as a father. He cherished spending time with his son, Kason. Joey's love for Kason showed no bounds. Joey served in the Army National Guard after attending Kaukauna High School. He was a dedicated employee for Carew Concrete Company, proudly working as a dump truck operator. His faith was a cornerstone of his life, bringing him much comfort and strength throughout life's challenges. His beaming smile, vibrant personality, charisma, energetic spirit, and great sense of humor lit up a room wherever he went. Joey's light shone brightly until his passing on July 18th, 2024. There are some who have a heart and soul that shine so bright that nothing can put it out. Not even you, Samantha. Joey's light will continue to shine in the hearts of all who love him. The only comfort I have is knowing that my son Joseph is now resting peacefully in the arms of our Heavenly Father. Joey is smiling down on all of us from heaven. Shame on you, Samantha, for the living hell and agony you have caused for my family and I.
All right, thank you to Ms. Swanningson. Court will consider the full scope of your statement. This time, we're going to take a break for about 10 to 12 minutes. We'll start up again. My clock is at 10:17 a.m. We'll start up at 10:30 a.m. and proceed. Do you have one more statement?
I do not.
Okay.
We can take a
The
break.
child's mother. All right, and from the defense, now that you've had more time to reflect on it, is there any statements beyond your clients?
No.
All right, before we get into the arguments, the court wants to get perspective from the attorneys as to any credit. So if you take a few moments and let me know what credit you think the defendant's entitled to.
I believe it would be July 22nd of 24 to November 24th of 25. The impact would be she has also been put on a probation hold. She's serving a revocation right now. So if the court runs it consecutive, I believe she would have no credit. If the court would run it concurrent to that, she has been on bond, I believe, since, or has been in custody on this case since then.
Okay, Ms. Rock?
I do agree with those dates.
Okay, we'll start with the prosecutors with their presentation and argument. Go ahead.
Thank you. In addition to the statements that were already provided, I do want to remind the court that the state did file a victim impact statement earlier. There is a letter from Kaysen's grandfather. There is also a writing from Kaysen in there, and I do want to remind the court that that is in the file and should be taken into consideration as well.
All right, I did read those in the last few days.
Thank you. In addition, there's a restitution summary that was provided. There is restitution in the amount of $7,962.81. There's an additional surcharge on there for a total of $8,769.09. I believe that based upon the statute and case law that those amounts are appropriate for restitution, I'd ask the court to order that. And the court should have the filing as well as all the documentation supporting that.
I have
Okay,
that. Yeah,
all
go
right,
ahead.
thank you. As we sit here today, we have had a lot of facts for the court to consider. And as we look to today's purpose in sentencing, we're required to look at the Galleon factors that are outlined by our case law and by our statutes for the court to consider sentencing. So while the court can consider the statements of all the individuals who have spoken and provided written documentation, we also need to focus on the defendant's character, on her actions, on her history in order to be able to address what the appropriate outcome is. There's really no good outcome today. A life sentence, no matter if there is an eligibility or no eligibility, is never going to bring Joey back. He is never going to be able to be part of Thursday's Thanksgiving dinner with his family. He's never going to have the opportunities to be the father that Kaysen should have. And there is nothing that this court nor any of us, unfortunately, can do to make that whole. And so when we're looking at what the next step is, it's what is just, what is an appropriate outcome. There's no doubt that Joey struggled with addiction, and he worked hard when he was with Brittany to get clean. Brittany, while she did not make a statement specifically today for sentencing purposes, I think there's a feeling from her that she provided so much about who Joey was and how he lived his life in her testimony that really outlines a lot of what we've also seen from Joey's family. He was a hard worker. He got a good job after he got clean. He did a lot of work to make that happen. He got his own apartment. We were able to see that video. He was so proud of his first dinner there. He was living independently and he was saving for retirement. And we have information outlined in the pre-sentence investigation about that amount of money that he had that Sam had used. Addiction is hard, and addiction, while at the core of this case in many ways, is not just the only part of the story. Joey found his way through addiction, and he found that he could work through that by getting the support that he needed from the community partners that we have for the programming that he was able to be part of, and then most importantly, through the support of family and friends. And I think that that's important to recognize because we know how strong that addiction struggle is, and we know that it takes a lot to be able to get clean. And I want to kind of juxtapose that to the conversation and the opportunities that Samantha has had and the different choices that she has made. But certainly he's responsible for himself, Joey is, and for his choices. And I think everyone here would agree that there were some choices that he made about his use towards the end that weren't good. But his addiction impacted his life and ultimately had a big impact on his death. But more importantly, I want to focus on his relationship with Samantha. Because even with all the addiction issues, there are people in our community that struggle with addiction and never see and experience this kind of violence, never perpetrate this kind of violence. His relationship with Samantha, honestly, at the time that we prosecuted it, she was in the process, or at the time this happened and we charged it out, she was in the process of trying to move to Appleton from Wisconsin Rapids. And you can kind of see that in her residential history. Knowing what I know now, I would have charged this as a domestic homicide because it wasn't clear if she was really living here in Appleton. And I think the transfer was in the process. But aside from whether or not that's a statutory thing or not, or falls into the definition or not, their relationship was clearly one of power and control. And while we often see and talk about that with men, we know that it can also happen with women. And we know that men can also be victims of domestic violence. When we look at protection of the community as one of the Galleon factors, we have to look at her prior record, her history of desirable behavior, her personal and social traits, age, education, employment, remorse, and cooperativeness, and then what rehabilitation would look like, because that's what the statute first wants us to focus on. I think it's important to note that while she's 40 today, she would have been 38 at the time she committed this offense. 38 is a grown adult, someone who is responsible for themselves, someone who makes independent decisions for themselves, is someone who needs to be responsible for what they do, how they act, and how they support themselves. Her adult life has been involved in ongoing criminal activity while also having the struggle of addiction. When we look at what's outlined in the PSI, according to her, because it wasn't documented by the agent contacting the school, but according to her, she graduated with honors, took college prep courses, and was involved in extracurricular activities. She didn't have any juvenile history that is outlined in the PSI or that I was aware of. And according to her, by all information, she had a good childhood. This is someone who had the skill set and the smarts and the ability to be able to make different life decisions at many, many different points in time. She has no significant work history, though. She has gone from job to job. She has not had consistent jobs other than selling drugs, which was consistent with what her phone download showed. That, and she talks about in the PSI, that she consistently has sold drugs as maybe a way to either have access or perhaps also just to support herself. But she has no reliable work history when I looked at the PSI. She does not have residential stability. She has moved around a lot. I think sometimes she's in and out of in jail. She's been in and out of prison. She has periods of time that I think maybe she goes back maybe towards her mom's. But she doesn't have any strong stability, work history, or residential history that she's created for herself by age 38. She has a child who she tragically lost as a termination of parental rights. My guess would be that there were a lot of supports and services provided to aid her through that, to help her with residential stability, to help her with getting her addiction issues addressed, helping her make sure that she was working, that she was living a life crime-free. I know from my experience in working with our county services that there is a lot of effort that goes into helping provide services so that we don't end up in that position. And I think that's important to recognize, because when we're looking at ultimately rehabilitation and we're looking at addiction issues, we're going to talk a little bit about what DOC provided, but I think we can't not look at the fact that she had would have had a lot of other access to other programming and support through social services before that would have ever even been able to happen. When we look at her prior record, she appears to have been revoked at least 3 times. In one case, I think it was even twice. Somehow she had gotten a deferred prosecution agreement, which I think might be consistent with when she was involved in the drug treatment court in Wood County. And she had gotten a deferred prosecution agreement on the felony, which she managed to turn into what I believe was a stayed 2 years, 6-month prison sentence that was ultimately revoked, suggesting to me that she then went to prison out of that case that started at a deferred prosecution agreement. I talk about the drug court because I also know that the whole purpose of drug court is to try to address addiction, to try to help people find stability in residence, to help them find stability in work history, to help them try to surround themselves with supportive, clean friends, family members that can help support them through recovery. And so I think outlining that is important to recognize that there have been multiple attempts to address this issue. But yet, when we look at her prior record, I think, and it could be corrected a little bit based upon Attorney Rock's comments about the shoplifting, and maybe those were addressed as ordinances, citations, I don't know. But I had about 20 cases with 37 convictions, somewhere between page 9 and 11. So it's somebody who has had a lot of contacts, regardless of how we look at it, even if it's -2 offenses. A lot of contacts, a lot of convictions, a lot of opportunities in front of the court, a lot of opportunities to be put on probation, a lot of opportunity to be put in drug court, and to be given as many resources as possible through Health and Human Services, through DOC, through treatment court, through sitting before court hearings and having the opportunity to address them. While on supervision on page 12, it talks about how there were numerous violations, with many of her violations resulting in new charges and revocations when she was put on supervision. The agent who wrote the PSI said her periods of supervision were, quote, overwhelmingly negative. There were times where she had multiple ATRs to different treatment programs, including the Wood County Drug Court, it seems. In treatment programs, she had to be placed sometimes on house arrest due to socializing with people who were using or not being compliant in different ways. Other periods of house arrest while she was on these ATRs, fake urine analysis that she had provided. In 2016, while she was on supervision, I believe, she was at a house that was largely for the sale of drugs and had a firearm and somehow accidentally discharged it at another. I don't know all the facts surrounding that case other than to say that it's outlined in the PSI and certainly concerning. On page 13, and I should say ultimately she was convicted for that incident, I believe, in Wood County case 16 CF 490, which was an injury by negligent use of a weapon or explosive. On page 13, it outlines in her correctional summary or experience that she had threatened another person who they shared a same significant other in some way, shape, or form. And she threatened to stab that individual and her family over an argument that they had. I think that that's important because that's what we see in this case. We see her making threats with weapons. We see her negligently discharging weapons. We see her now having the threats that we heard from the witnesses in this trial, where there were previous threats of her stabbing Joey. We hear the phone call of her saying, you know, who doesn't threaten to stab their boyfriend? And we hear those comments, which in light of her history and having that addressed from her threats down previously, knowing that she can't just say things like that, and the threats being considered real and concerning, and having to address that through supervision, to the threats that we have of Joey's life that his coworkers had heard. And then we combine it with the fact of how he died and how she had stabbed him. I think it's really critical to see that increasing level of violence over time. So not only are we having the addiction and drug use issues, which alone are concerning, which alone have significant criminal ramifications, but you're seeing a pattern of violence and threats, use of weapons, and behavior that ultimately in this case has now caused the death of another in an intentional act. So that now has increased our concern over community safety exponentially, not just for romantic partners, but we know that she's made threats and harmed other people previously. In her additional convictions, while largely drug related, we do have batteries, disorderly conducts, criminal damage to property type cases. And then we had a domestic back in 2004 in Wood County. That was also a domestic battery and disorderly conduct. So I think it's important to kind of connect that domestic piece that we saw early on with this increasing violence over time while she's using. In addition, we look at everything that the community has tried to do to address her drug use issues. And she talks about how she would like to be able to live in the community and be crime-free or not be using. But that kind of leads us to page 22 when it talks about her prior experiences in treatment. And in that kind of leads us into that second prong of the Gallian factors with rehabilitation of the defendant. So we're looking at opportunities that she has had for treatment, what she would need moving forward. And we look at page 22 that says that Krebs has been offered and participated in numerous treatment programs in the community and while she has been incarcerated. This includes Affinity House, Wood County Adult Drug Treatment Court Program, inpatient and outpatient programs from Human Services. In prison, she's participated in cognitive behavioral programming, substance use disorder program, challenge incarceration program, and an earned release program. So we see someone who's basically been offered all the program and services that we have, and yet not is she just continuing to use, but she's continuing to engage in criminal activity and leading to somebody's death. She talks about how she wished she would have taken treatment seriously to live a life free of crime. And we think about how she got released, it says in November of 2021. So 4 years ago, she was released, and how she continued to use and reoffend after that. One would think that at the point in time where she is in the Wisconsin state prison system, she's receiving services through in custody services, and then ultimately is released to extended supervision, that really would have been the turning point, or the termination of parental rights, the turning points where she would have realized that she really had to address the substance use issue. And I'm not trying to make light of how hard it is to address substance abuse, because I appreciate the fact that it is extremely challenging in our community. But it is also a problem when it continues to lead people into additional actions that lead to additional crimes. And certainly when you have the loss of a life by first-degree intentional homicide. For whatever reason, all the programming that she had really didn't result in a change in behavior, because what we then saw is even on the day of the homicide, and we had plenty of testimony from her and other information to show from text messages that she was continuing to use that day. Well, Joey was at work. Well, Joey was pending that child custody hearing coming forward. He was trying to do the right things. When we look at what those that day looked like, that morning starts by, "Good morning, my shine bright like a diamond. I would love to make home cooked meals with you and be partners in the kitchen." And then he talks about, "I know you have a lot going on. It's okay. Just can't wait to say I do." A lot of those messages that we saw during trial are really so interesting when we compare them to the messages that his sister was getting from him. Messages of just reaching out and checking in and showing love and care for someone. And that's what he was doing on that particular day. We think about those other messages that had the picture of him at a construction site and him saying, "I'm right by the house. Come say hello. What are you up to? Hello, I'm on my way home." So he's messaging her that day, and she's sitting in her house or in his apartment, using drugs, smoking meth, not working, while he is engaging in this very, what I would consider, thoughtful, caring response. He also then quickly, "Sorry, I think I overreacted. It's all good. No worries." And I start to think about that domestic violence tendency where somebody does something where she's engaging in this behavior, and then he's quick to respond, "Oh, I'm sorry. I overreacted. It's all good. Don't worry about," trying to kind of smooth over the issues of whatever was happening. And then he sent her a text, "I just don't want to talk about that while you're with Johnny Boy." Well, she's there in the living room smoking meth. Then he says, oh, no worries. I ain't going to touch his stuff, but I was going to sit down and watch TV or whatever. And then I see a bitch in front of me, where he's talking about how even in his own home, while he tried to create this space, well, he knows that he has this child custody hearing coming up. Well, he cares greatly for Kaysen and wants to have custody and knows he needs to get clean, because we heard from Brittany about the conversation she had with him when he was able to make a phone call when Samantha wasn't there, and called from his original number, which she thought had been disconnected, according to them, because she was only allowed to talk on Sam's phone number. number because that was the number she was given. Again, that power and control tactic. But he reaches out and he's upset and he wants to get clean. He wants to be able to get his life back in order, but he struggles because he also loves her. He loves her, but he doesn't want the behavior to continue. And he's saying in here even that he doesn't want that bitch or that meth that was in there. That night, we have an opportunity for him to be able to go see his uncle and cousin. And there were text messages that we talked about that night at 8:42, which was about an hour before he died, that he ended up canceling. It ends up having conversations in text and then a couple quick calls where he was supposed to meet up with one of his uncles and his nephew, and that never really happened. And we hear from the family and we hear about this isolation that he has. We think she's in the living room smoking the meth. We have the text messages in here about how she says Chong left. He had been there. She was eating a bowl of ice cream, and they're talking about how she's still high. And her answer is, should I not be? Again, even her use surrounding him. And she talks about wanting to be the stepmom, and she talked about wanting to be married to him. And yet things are spiraling out of control for him for sure. She's using significantly. I don't know if one would say her life is spiraling out of control at that point. It seems to be kind of consistent with her use and being home and not doing much. He's trying to put the train back on the tracks. It's not happening because he's also in this relationship that is a really codependent drug use relationship where even when he comes home that night, he had texted her earlier that day about wanting to make food in the kitchen together with her and some really kind of quote unquote normal relationship behavior. And then he's struggling because he's in his bedroom, according to her, while she's out there smoking meth. And he ends up using that night. Now, was that his choice? Sure, it was his choice. But it's this environmental factor with her that is also continuing to create a lot of issues for him. Then at some point in time in that hour after they start using, there is definitely an argument about something. I think it's interesting because he's at that point, he knows he needs to get a clean urine to have a urine screen done for work. He's struggling probably, and of course I don't know this for sure, but struggling with the fact that he used because he knows he has to get a clean urine in order to be able to pass this work test. There is, according to her, some argument. She claims that they're talking about his son. But based upon her testimony and constantly changing stories, I don't know what happens in those minutes when they're in this argument and what starts the argument, what is said, who is saying what, because I can't believe anything that she says about what those minutes were leading up to it. Based upon her testimony, it would change within sentences of each other. It was so inconsistent that everything that she said was not true. And when we look at that dynamic and we think about how she started to develop her story, she's high. We know that. There has to be some type of anger. She stabs him. And then the response is.
Okay, so they are back from court from their lunch break. I tried to speed it up just a little bit, guys, so we could try to get through it, but she going on and on and on. And I know we don't want to miss anything of our girl Sandra, right? Her breaking moments. So I'm gonna take us back in. And if we have time, then we'll finish up, guys, okay? She need that Shorty Wanna Be a Thug song. Shorty Wanna Be a Thug. That's what she looked like, boy. I want her to part the middle of her hair and braid her braids again. I don't know if I like her looking like a thug. Shorty Wanna Be a Thug. An extra from the Orange is the New Black. Yeah, she might be. Oh, Shorty Wanna Be a Thug. That's all I can think about when I see her. Oh gosh. Well, I hope we can get past this. Wait a minute. Cause Shorty Wanna Be a Thug.
Please be seated.
Mr. Johnson, if you want to come on up. All right, we're back in the record in 23-110 FC People versus Shanda Vander Ark. Where we left off, Mr. Johnson was on the stand. I think the parties had concluded their questions. The court did have some questions for Mr. Johnson. Mr. Johnson, you obviously know you're still under oath.
I do.
All right. Let me just see here. There were some questions about by Mr. Ambrose regarding the suspension.
Yes, sir.
That I think occurred, last year or this
I
year?
served it last year. It took almost 9 months to get the process rolling, so it actually occurred the year before.
All right. And
Well,
my understanding, you've actually been here and a get their hearing for that case, correct?
For that case,
In
yes,
this
but
court.
not for that issue.
And not for that issue, but in this court, correct?
Yes, sir.
In this very courtroom, correct?
That is correct.
Okay, and that was for it was People versus LTJ Udall, is that correct?
Yes, sir.
And that was 2019, I think it's 947 FC.
Yes, sir.
All right. And I just wanted, for the record, my understanding is the basis of the disciplinary action was that in that case, let me just go back. My understanding of the facts of that case, very briefly, Mr. Udall was charged with criminal sexual conduct, I think in the first degree. Is that correct?
Yes.
Okay. And the victim of that charge was a client or represented by the public defender's office. Is that correct?
Yes.
And that was in an abuse neglect case or an NA case, correct?
Yes.
All right. In my understanding, you did not actually handle that case, correct?
That is correct.
And was it other members of your office that had handled that?
Yes.
And my understanding is there was a file that was taken from your office detailing this minor child's counseling records, psychological records. Is that correct?
Yes.
And my understanding is that you actually used those in Mr. Udall's defense.
I saw them. They weren't used.
They weren't used, but you certainly used them to prepare.
Yeah, yes, sir. I read them and I knew.
And my understanding is there was supposed to be you were supposed to isolate yourself from that. It was set up to isolate yourself from those files because you knew could be a potential conflict. Is that correct?
Yes, sir. We had processes in place to make sure that didn't happen.
Okay. And that did not happen.
That's correct. The processes failed.
And so essentially you actually used what were supposed to be withheld from you.
Yes.
In that case, Mr. Udall's case. Is that
Yes,
correct?
sir.
And that was the basis for the judiciary or the complaint.
Yes, sir.
Grievance, correct?
Yes, sir. It was.
And you admitted that this happened, and I don't think you contested it at all, correct?
That is correct.
All right. And that's the basis for the disciplinary action, as far as you know.
Yes, sir.
All right. As far as you know, did the disciplinary action have anything to do with, not getting back to your client or not talking to her, doing something that you weren't supposed to do in terms of representing, something similar to what's being alleged in this case?
No, sir.
My understanding is that there was Mr. Udall's case actually had 2 trials. Is that correct?
Yes, sir.
All right. And you represented Mr. Udall in the first trial. Is that correct?
Yes.
And what was the result of that trial?
That was a hung jury, Judge.
Okay. And then the second trial, I have, at least according to what the records say, is they occurred in December 13th to December 15th of 2023. Is that your recollection?
Yes, sir.
Okay. Now, you had testified. Mr. Ambrose had asked you about, your stress level at that time. You were on a conveyor belt.
Mm-hmm.
Was that true at the time of the second trial in Mr. Udall's case? That you were on a conveyor belt? I think that's one of the reasons you said what was going on for the disciplinary action. Is that true?
Judge, it was that the workload continued unabated for the time I was at the public defender's office. It was self-inflicted. I didn't go on vacations. I didn't. When I retired, I had 50 more days of vacation time that they didn't even compensate me for. I was at that office and I was doing that work. So yes, it was a continuation of the same process throughout the entire time. The only difference being was when it came to a capital, well, it's not capital in Michigan, but a life case in Michigan, the priority shifted so that the time that I needed for that case would shift to that big case, the life case, as opposed to misdemeanor cases I might be working on.
And I actually misspoke. So my understanding, I got this trial, Ms. Vander Ark's case actually took place between December 13th and December 15th of 2023. Is that your understanding?
Yes, sir.
I had it wrong. That Udall case happened in April of 2022. Is that your recollection?
I thought so. I thought his was done by the time Ms. Vander Ark began.
Okay, so this trial,
yeah.
Did you go right from the Udall case to focusing on Ms. Vander Ark's case? Because it looks like they went from April 2022 and then a little over a year later, you're trying another FC case.
No, I think there were at least a few weeks in between. I don't think so.
All right. Now, was there, looking back on it.
Yes, sir.
Were you able to give Ms. Vander Ark's case what you felt was the appropriate amount of attention for an FC case?
Yes, sir.
Okay. All right. Was that with the assistance of the people you've already indicated?
Yes, the team did.
It wasn't all you, it was the team.
That's correct.
All right. And would you say that you were in charge of the team? Like,
yes, sir.
You weren't absent and said, look, you guys do all the work, I got to take care of everything else. Or were you there for meetings? Were you there for other stuff?
I was there.
Okay. All right. And I'm trying to understand the defense strategy. Okay.
Yes, sir.
From what you've testified to, my understanding is that your strategy was to essentially go from a intentional crime to a negligent crime. Is that correct?
In effect, yes, a crime where there wasn't the mens rea to commit harm. So yes, sir.
At the break, I looked up the jury instructions, and it looks like you. Correct me if I'm wrong. I can't remember exactly, but did you ask for the involuntary manslaughter instruction?
We did not.
You did not.
No, sir.
Okay. But it was included, correct?
Yes, sir.
All right. Was that at the request of the prosecution? Do you recall?
Now that you mention it, I don't remember who asked for it. Now that you mention it, I don't know, because we obviously, for the record, we discuss these instructions in chambers, and the instruction, it would have come up. I don't know who asked for it. It might have been me. I don't remember.
Okay. So my question is this: you had testified at the beginning of Mr. Ambrose's questioning that Ms. Vander Ark had not given you consent to ask the jury for a manslaughter verdict.
That's correct.
Was that your testimony?
Yes, sir.
But then later on, you said the focus was going to be this is not an intentional crime, that there's just something wrong with it, correct?
Yes, sir.
My question to you is, when these discussions you and Ms. Vander Ark, did she unequivocally say, I am not guilty of any crime? Or was the discussions, look, I didn't do this intentionally. I didn't mean to do this. I'm not going to plead to something that I didn't intentionally do. Was there a dichotomy in that discussion?
The discussions about her responsibility came in two phases. The first phase, when we first met, she told me the same thing she told the police at the time that the boy was discovered, that she found him in the bunk bed, she pulled him down, and she's trying to administer CPR, and et cetera, et cetera. That's the first thing she told me. Then after that, once we got past that and the police reports came in, it was clear that wasn't the situation. We talked about individual defenses to individual crimes. And we covered everything. We covered all the things that she might be, that her conduct might find, the jury might find her guilty of. I never directly challenged her, did you do something here? And that's not my way. If a client either wants to talk to you about that way or they don't want to. But based on the conduct of our conversations, it was clear that she was aware that there's something that's wrong here. There's something that I may be found guilty of. And that's kind of how we kind of, in order to bridge the gap from her having to confess to me, we kind of discussed it as there's something you might be found guilty of. And this is the things you might be found guilty of. And this is the things that we might be able to achieve if we do these sorts of things. And avoiding, and the bottom line is avoid first degree murder.
So it was never, she never said, well, I'm guilty of something. It was more of discussion about, okay, throw it all out the window. What could the jury potentially find? And what's a mitigating thing we can do? Is that right?
That was the strategy, Judge. It was never, I never confronted her to ask her if she did something wrong or not. I gave her the way out. The jury might find you guilty of these things. What are we talking about? And that's how we bridge that gap.
So there was never an affirmation on her part that I recognize that I am guilty of a not unintentional type of charge.
Never before or since.
Okay. And it sounds like initially you wanted to find an expert witness to assist you in that defense, correct?
Very much so.
And you went through, you tried 2 different expert witnesses, is that correct?
We hired 2 different ones.
Okay.
We talked to 3 or 4 others, and we talked to other people, but we hired 2.
Right. And is it your testimony you could not find an expert that could assist you in that defense?
Yes, sir. That is my testimony.
Did you discuss with Ms. Vander Ark that you were going to make the argument to the jury that she was guilty of an unintentional, negligent type version of either manslaughter or homicide? Did you ever discuss that with her, that was the strategy?
I can tell you how we discussed it. First degree murder is an intentional homicide. You didn't intend to do anything. And that's the argument we're going to make to the jury. That's how we discussed it.
Did she ever say, wait a minute, no, I don't want you to do that because I'm not guilty of anything here?
No, Miss Vander Ark, again, she was the client from heaven. She sat and she listened and we talked. She understood, and then she trusted my judgment. At least her conduct indicated she trusted my judgment from that second week on. The only thing, Judge, we ever had a crossword on was about the Michigan-Alabama football games.
So again, she never said, Mr. Johnson, that is not an argument I want to make. I am maintaining my innocence to every single thing that I am innocent, and I absolutely do not want you to concede any sort of guilt in any way, shape, or form.
That is absolutely correct.
Okay, that she did not.
She did not. Not ever.
And you feel, coming from defense background,
Mm-hmm.
sometimes defense attorneys have a tendency to kind of, they think they know more, they know what's better for the client, right?
Yes, ma'am.
I know you don't want to do this, but we're going to do it anyway because I want to make sure that we're successful here.
Yes, sir.
Did you do something that she did not want you to do to be successful, or did you do what you had to do in consultation with her about what the strategy was going to be?
The latter. And again, this is a different client than what we normally receive. This is a client who's much more sophisticated about the law and had much better understanding. And our relationship was more co-counsel, or maybe senior counsel myself and junior counsel myself, but more co-counsel than lawyer layman or layperson. She understood the strategy. She conceded that was the strategy that we were going to use at trial. She understood it. She knew I was going to do that. Did she know the exact wording or how it would come out? No, she didn't, because I didn't. But she understood it, and she understood what we were going with. And at no time did she express concerns that I don't want to do it that way. I want to go on and say, I didn't do anything. I wasn't even, whatever her argument would have been. But no, I never asked her if she committed the offense. She never told me she didn't commit the offense.
The other question I have is, in all these discussions, I mean, obviously you're saying not first degree, not premeditated.
Yes, sir.
Not second degree, not because that's an intentional crime,
Yes.
right? Not necessarily voluntary manslaughter,
Yes.
but was there ever discussion? Well, listen, this is the charge. We think. Let me back this up.
Okay.
You had said you argued to the jury manslaughter because you were hoping that they would find a middle ground and go for second.
Yeah. Yes.
Was that the strategy that you guys came up with? Or was that kind of like in your mind, you said, well, wait a minute, worst case scenario, maybe it'll be second, but I really want manslaughter?
Okay. No, this is a strategy that I came up with. We did not come up with it. This is the strategy that I suggested to her, and I told her that I was going to follow. And this is, and at no point did she express to me that, no, I don't want to do it that way.
When that final day when she was, it was last day of trial,
Yes, sir.
you indicated she was in a ball in the holding cell. Did you ever suggest doing Zoom, potentially? Her zooming in from outside the courtroom for the trial?
No, I did not.
Okay. Did you feel rushed at all that morning by either myself or the court or anybody else to kind of say, let's get this rolling? And
Not rush. I wish we'd have adjourned it for another day to see if she could come around, but no, I didn't feel rushed. I understood that the issues were presented to the court. The court made its call. It wasn't that that the court was trying to rush me to do something. It's just that this is what the court thinks is we're going to do, and so that's what we do. I didn't feel rushed. I just felt okay.
it was we did. I think we waited a couple hours, correct?
We would, yes, sir.
And now I want to make sure, I mean, you're obviously aware of the legal definition of competency in terms of state of Michigan.
Yes, sir.
Could she rationally assist in her defense? Does she understand your job, the prosecutor's job, the court's job, the jury's job? Do you feel that she was legally, according to the standard of the state of Michigan,
right?
Would you believe that she was legally competent in everything that you observed that day?
Yes, sir.
Did she ever ask, say, hey, listen, I want you to ask these certain questions?
No, sir. She directed me to ask very few questions. She had observations, but she didn't.
I'm talking about that day.
Oh, that day. No,
state. Okay.
No, sir.
I think her affidavit says she had a lot of questions that she wanted to ask the witness. I think what part of them, I might paraphrase.
Mm-hmm.
I'm just wondering if those were ever communicated to you when she was in that state.
No, sir.
Okay. All right. All right, that's all I have. All right. Any follow-up, Mr. Ambrose?
Yes.
Yep, go ahead.
It was your request, the lesser included. Is that correct?
Probably. It was a chambers discussion when we talked about the instructions, and so I don't have any specific recollection, but probably I can't think why the people would want that instruction.
May I approach?
You may.
And this is a transcript of December 15th, 2023. Page 41 near the bottom and going to the next page.
Okay.
Does that refresh your recollection that it was your desire, your request for the involuntary manslaughter instruction?
Be honest, counsel, I still don't remember asking for it, but I don't have any reason to dispute what's written there in the transcript.
And it does say that
That
Mr. Chambers or Mr. Johnson is your. So my understanding from our discussion in chambers, Mr. Johnson, is you're requesting an instruction on lesser included offense of involuntary manslaughter. Is that correct? And your response was, that is correct, Judge.
Okay.
All right.
Yes, sir.
I agree with that. So it was your request.
Clearly.
And so my client's, Ms. Vander Ark is not in the courtroom at this time, correct? December, that's that Friday.
If that same day?
Yes.
No, she's not in the courtroom.
And you're not discussing involuntary manslaughter with her when she's balled up on the floor, right?
That's correct.
And she's catatonic, right? What you said.
It's what I said to the pressed, sir. She was distraught, and she was literally curled up in a ball and crying on the floor.
And you're not discussing with her at that time, or are you? Hey, I think I can go with the involuntary manslaughter. What do you think?
Correct.
All right. And throughout, from day one, Ms. Vander Ark said that she was not guilty of this offense. She maintained her innocence. Is that correct?
As I've said, I never asked her if she did it, and I don't recall her saying I didn't do this. There's quite literally videotape of her conduct, so I don't recall her ever saying I didn't do anything. What I recall is she never told me that she intentionally did anything to her child or to any of her children. And that's what I recall. I don't recall her saying, I'm not guilty. This is not me. I didn't starve my child, that sort of thing.
Did you guys ever have a discussion? Ms. Vander Ark, you kind of meet these elements of involuntary manslaughter. You want me to see what I can do with the prosecutor, see if they'll accept a plea?
Sort of. What we talked about was she's charged with this homicide, and these are the possible outcomes a jury could legally come to, and these are what they require, and it may be and we talked about it. If we're winning the trial, what do we do? If the trial's not going sideways, what do we do? That sort of thing. But she understood that there are options, and that and during our conversations, my conversations with her, that we talked about what we might argue on if the facts support it. Does that make sense?
Well, you mentioned on direct in the morning, it was kind of your decision to argue to the jury that she's guilty of involuntary manslaughter.
That's correct.
My client, Ms. Vander Ark, never said I'm guilty of voluntary manslaughter.
That's correct.
And just as a general question, on December 15th, when she was, on the floor and in distress, did you request any type of medical assistance or to have her evaluated?
No, sir.
Your Honor, I don't have any further questions.
Just a couple briefly, and Your Honor, I guess I would just ask the court at this point in time to take judicial notice of the opinion and order regarding new trial in the LTJ Udell case. I do have extra copies. I wasn't anticipating admitting it, but given the court's questions, I think it's just come up. There's been a Ginther hearing. This is the court's ultimate opinion on the matter. So I just asked the court to take judicial notice, and I do have a copy for admission if the court wants it that way versus.
Yeah, that's fine. I think I can take judicial notice of it, right? If you're asking, because it's in the file. So
I would just mark it as people's too, or proposed to.
All right, Mr. Ambrose. Any objection?
No. Court record.
Thank you. Do we have exhibit 1 too, by the way? Is it still on this?
It is.
Is it needed anymore? Or I was just gonna make sure I keep track of the exhibits. So, all right, good enough.
Mr. Johnson, is it? I'm sorry, Your Honor. May I proceed?
Oh, so this is the opinion order in the LTJ Udell case, correct?
Correct.
Okay, all right. I wasn't, Mr. Ambrose, were you aware of that?
Yeah, I mean.
I wanted to make sure we're on the same page.
Yeah.
Okay, yep, I remember it. So wrote it. Good enough. Go ahead.
And just to confirm, it's been admitted.
It is, yes.
Mr. Johnson, is it fair to say that you're aware that involuntary manslaughter is a necessary lesser included offense to murder?
Yes, ma'am.
Okay. So if the record shows that you requested it, would that be a standard course and an open murder charge to ask for that?
Most certainly.
And you did in fact go over involuntary manslaughter and what that would entail with your client.
On multiple occasions.
Okay. And so it's not that she's in the jail, she's away from you, and you just decide to ask for the instruction right then and there without consulting her.
Well, I didn't ask her if we could put in the instructions, but we talked about that argument being an option.
Did she condone that option?
She doesn't do that. She doesn't say, okay, you got it, I will do it that way. She simply, I tell her this is what I think we should do, and she nods and yes, and okay, and that sort of thing. She's not the kind of person who was gonna challenge, I think. She understands and she trusts.
Did you feel that she was aware about the strategy about attacking the mens rea elements?
Yes, ma'am.
And based on your knowledge, mens rea is different for first degree, second degree, and manslaughter, correct?
Based on my knowledge, yes.
So while you might not have used the words manslaughter, was she aware that there was going to be some concession of mens rea in some way?
Okay.
Maybe negligence or something along those lines?
We discussed options prior to trial, and I told her what the options were, and that as depending how the evidence came in, we would select one of the options. One of the options I told her that I would be selecting would be this negligent homicide argument. So did we sit at the table and talk about it during the trial? We did not, but she was aware that was an option, and she was aware I was considering it, and she never objected to it.
Thank you.
Mr. Amber?
Did Ms. Vander Ark ever express to you her guilt of anything?
No.
And her testimony at trial, would you agree, was an expression of her being not guilty?
Yes.
Of her belief?
Yes.
That she was not guilty of anything?
Yes.
I don't have any further questions.
Top to that.
No, thank you.
All right. Mr. Johnson, I just want to clear, I think we're all dancing around the same question here. Did you ever say, hey, listen, I'm gonna, to her, in those words, we're gonna go for involuntary manslaughter?
No.
When you said possible outcomes, did you mean, hey, listen, open murder, you can be first, second, voluntary, involuntary? Is that what you discussed with her?
That's what we discussed.
Okay, and did you discuss all the elements of all those?
Yes, we did.
Okay, and it sounds like you discussed 1 and 2 are off the board, correct? I mean, that was not something you guys were gonna argue, correct? First and second degree.
Most certainly not.
Okay, and when you guys talked about, so my understanding is as the trial progressed,
Mhm.
you were waiting to see how the proofs came in, to see exactly what manslaughter was going to be argued or just complete in it. I mean, did you ever foreclose the idea of the argument to the jury that completely not guilty of everything?
No, sir. That's the first argument.
Okay. And then was it, okay, listen, depending on how things go, then we might have to say, all right, well, that's out the window. Maybe we should argue involuntary manslaughter.
Yes.
Right. When you guys discussed this, did you use those terms, involuntary manslaughter?
Yes, by name.
Okay, so you actually said involuntary manslaughter to her.
Yes.
And you believe she understood that?
Yes, both manslaughter by name. She's a lawyer. She understood. So I wasn't as reticent about but by breaking it down as I normally would be. She understood all 4 the options, and we talked to them by name.
Okay. When did it become apparent to you in the course of the trial that the complete innocent verdict was gone? The fact that you were gonna go for not guilty completely. That you said strategy number one. When did that occur to you that that went out the window?
Judge, if you'll recall, there was a point in the trial where the witness testified that he sent my client a photograph on his phone of Timothy and he was shirtless and the pants were falling off of him, and he sent this photograph to my client, and my client saw it and responded to it. At that point, given that the jury, at that point, it became clear to me to tell this jury that there is no guilt here, was not going to be an effective argument for this client.
Was that discussed with Ms. Vander Ark?
Specifically, no, not that specific.
After that day, did you say, hey, listen, option one's off the board, we're gonna have to go with option two?
No, sir.
At any point in time was it discussed?
No, I did not. I would assume that had she been here, we may have, but that's just an assumption. I don't know. But certainly the decisions that were being made during trial, whether or not she was going to testify or not, that was done at the point when it became obvious that it might help her. But matter of fact, that's the other decision that was made when that picture came in, that she's going to have to testify. But no, there wasn't a sit down discussion saying, hey, we're gonna go for an involuntary manslaughter here. That did not happen.
Were there previous discussions that at some point that could happen? That you'd have to be, if one was off the board, you have to move on to option two?
Were there, you mean?
With Ms. Vander Ark?
Yes, that was discussed. Yes, that was discussed along with, and I reviewed the file, I knew it was in it, along with the likelihood that not guilty was not likely here, that we would probably be doing something to make sure you don't spend the rest of your life in prison.
When the option of involuntary manslaughter came up in all these discussions, was it ever expressed by Ms. Vander Ark? Absolutely not. I'm innocent.
No.
All right. Sorry to open the door again. Mr. Ambrose, any other questions?
Yes, okay, so during the whole trial,
Mm-hmm.
you hear all the prosecution's case, right?
Yes, sir.
And in the trial, you make a decision or you discuss with Ms. Vander Ark that it's probably in her best interest to testify, right?
Yes, sir.
And that occurs when this photograph shows up or appears. That was a reason to have her testify, or is that?
Yeah, there was as you know, with trials, the information accumulates, and when that piece came in, that.
Now, during your questioning of Ms. Vander Ark, do you ever ask her, Ms. Vander Ark, or sounds to me like you committed some sort of crime?
Did I say that? No.
And you never asked her on direct examination, well, don't you think they have a case here for involuntary manslaughter? Do you ever ask her anything like that during the trial?
No.
And I think on direct examination, you kind of said that it was your argument to make to the jury that she was guilty of involuntary manslaughter.
Yes.
And yeah, I have nothing further.
Just very briefly.
Mm-hmm.
She wasn't convicted of manslaughter, was she?
No.
So the jury rejected your concession anyway.
Yes.
So there's no, well, never mind. I have no further question.
Any follow-up to that, Mr. Ambrose?
I'm through.
All right, good enough. May this witness stand down, Mr. Ambrose. May he be excused.
Yes, thank you, Mr. Johnson.
All right, thank you, Mr. Johnson.
Thank you,
You
Your
are
Honor.
excused. All right, Mr. Ambrose, you can call your next witness.
I will call Shanda Vander Ark.
All right, Ms. Vander Ark, if you want to come on around. Please remain standing and raise your right hand to be sworn as best you can. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Shanda Vander Ark, Shanda Vander, space capital ARK.
All right, go ahead, Mr. Ambrose.
Ms. Vander Ark, you heard the, well, first off, your medical condition, let's just briefly go through that. How's your condition right now?
I'm miserable. I'm lightheaded. My head is just splitting. The back of my neck hurts constantly. It's something that goes along with the thyroid issue, I guess. I've been shaking. This is almost constant now. It started a couple days a week for a few hours at a time, and it's almost constant now.
Would it be your preference to testify at another time?
Absolutely. I feel like garbage.
With that, Your Honor, I would renew my request for an adjournment.
Can I have a sidebar with the attorneys real quick? All right, we're back on the record and People versus Vander Ark. Ms. Vander Ark, you can stand down. You can go sit next to your attorney. Well, this is, as a practical matter, it's 1:49 p.m. The people indicate they have 3 witnesses they wish to call. Mr. Ambrose obviously prefers his client be in a better medical condition. Quite frankly, this is likely to go on past today anyway. So because of that, there's really no point right now in pushing her testimony forward right now if she's not feeling well. I think the parties, and correct me if I'm wrong, agreeing, Mr. Ambrose, you don't have any objection to the prosecution at this point in time calling her witnesses out of order. That way we can come back here for Ms. Vander Ark. Is that true?
That is true.
Anything, Ms. Bloomquist?
I'll leave it in the court's discretion, but I'm ready to proceed with my witnesses.
Okay, well, let's do that. So, Ms. Bloomquist, you can call your first
The
witness.
people call Melinda Kotecki.
Ms. Kotecki, if you want to come right up here, please. Raise your right hand and be sworn, please. This matter now pending. Do you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Melinda Kotecki, Melinda Kotecki.
Go ahead, Ms. Bloomquist.
Hey, good afternoon, Ms. Kotecki. Could you please state for the record where you're currently employed?
The Muskegon County Public Defender's Office.
And what is your job title there?
I'm the Chief Social Worker.
And how long have you been employed there?
Just over 2 years.
And before you were at the Muskegon County Public Defender's Office, what's your educational history like?
I obtained my bachelor's degree in social work from Kuiper College in 2011, and then got my master's degree in social work from Western Michigan University in 2015.
And did you work anywhere after you received your degrees before the Muskegon County Public Defender's Office?
Yes, after I got my bachelor's degree, I worked at an inpatient psychiatric hospital, Pine Rest, and also worked at a residential treatment center for eating disorders. After I obtained my master's degree, I worked at Community Mental Health of Kent County for 8 years before coming to the Public Defender's Office.
Okay, so how many years in total have you been a master's level social worker?
It'll be 10 in May. Yes.
And were you the social worker assigned for the Public Defender's Office to the case involving Shanda Vander Ark?
For part of it, my understanding is I believe that she was arrested prior to my hire. Once I was hired in September of 2023, that's when I began working on the case.
And could you just describe for the judge, was there a defense team working on Ms. Vander Ark's case?
Yes. In addition to the attorney, Fred Johnson, there was also a second chair attorney, myself, my understanding is that the social worker prior to my hire had met with Ms. Vander Ark, and our office also utilizes a research attorney and an investigator.
So this wasn't just Mr. Johnson and yourself, there was a whole team.
Correct.
Correct?
Yes.
Okay. And did you meet with Mr. Johnson and Ms. Vander Ark together?
Yes.
On this case?
Yes.
How many times would you approximate that happened?
Prior to her trial, I believe twice. During her trial, we met daily.
Did you sit in on the trial?
Yes.
And I apologize, I'm not aware, but where were you at during the trial? Were you near counsel table or were you in the gallery?
Yes, I was near counsel table, not at the table with Fred and Ms. Vander Ark, but in the chairs directly behind.
So you were aware of what was going on during the trial?
Yes.
Were you there every day?
Yes.
So let's talk about the time before trial and those meetings between Mr. Johnson and Ms. Vander Ark. How would you describe Mr. Johnson's interactions with her?
I would, from my perspective, it seemed as though they had a good working relationship. They seemed as though they, communicated freely, both about the case and even just seemed to have an overall good rapport, I would say. They both were big sports fans and they talk about football. From my perspective, recognizing that they likely had meetings without me present as well, it seemed as though they communicated openly with each other.
Did it ever appear as if Mr. Johnson was just going to do things his own way without consulting her or taking her feedback?
Not at all.
Was he receptive to collaboration with her?
Yes.
How was her demeanor in those conversations?
I would say that she seemed very engaged. She was very eager to offer her own thoughts and feedback about kind of case strategy and it's, I guess, demeanor, mood-wise. I mean, she seemed, I guess I'm repeating myself, but the best word I can think of is she seemed very engaged.
Now, you did mention though that she had thoughts on strategy. Were you present for discussions on trial strategy?
Very minimally.
Okay. What was your minimal involvement on that? Or at least what did you observe, if anything?
I want to make sure, I guess, that I recollect as clearly as possible. So excuse my pause. The conversations that I remember involved talking about obtaining an expert evaluation, a psychologist to evaluate Ms. Vander Ark, and we all agreed that that was a good next step. So that's the primary discussion that I recall as it pertains to strategy.
Okay, so obtaining experts and seeing
Yes.
what their opinions would be.
Yes.
How generally was Mr. Johnson's tone with her?
He's one of the friendliest, warmest individuals you probably will ever meet.
And he continued that in his client meetings with her?
Yes.
Did Ms. Vander Ark ever complain to you about Mr. Johnson?
No.
Did you also assist in this case with Mr. Johnson when the defendant was not present?
Yes.
Okay, how so?
He and I would primarily discuss any updates if we were waiting for the psychologist to report back to us about his findings, or I guess that's the primary thing. I can't recall anything else specific.
Did you assist in sort of facilitating the interviews with the expert witnesses?
Yes.
Okay. And specifically, did you assist in or did you participate in the interview with Dr. King?
Yes.
And when I say that, I don't mean your interview with Dr. King, I mean the
Correct.
defendant's, correct?
Correct.
Okay. And ultimately, at the end of that interview, was a preliminary assessment given by Dr. King?
Yes, I
What was
was in, I guess to clarify, I am not the person who initially contacted Dr. King to arrange the assessment. I believe that was done by the social worker that was employed before me. When I was hired, that is when I kind of took over that role. I did participate in the interview with Dr. King, and after Ms. Vander Ark had ended her portion of the call, Dr. King and I were still on the call together, as well as I think he had a research assistant that was present. And I am not quoting by any means his exact words, but his initial or preliminary assessment was that he did not feel that Ms. Vander Ark was incompetent or severely mentally ill, and felt that there was not, he could not provide a good defense for our office.
Was Mr. Johnson on the call at the same time as you, or was that just
He was
you?
not.
Okay. So you obtained that information. What do you do with it?
I told Mr. Johnson about it.
And then, to your knowledge, and only answer if you know, did Mr. Johnson speak to Dr. King as well?
I don't know for sure. I know that Dr. King sent us a report. I don't know if they had a separate conversation.
But he wasn't a party to the conversation with you and Dr. King?
Correct.
Okay. So, Ms. Katecki, in your professional capacity, do you sort of have to assess whether or not individuals are alert to person, place, and time?
Yes.
Okay. And do you just sort of naturally start to do that when you're communicating with defendants at certain points?
Yes, definitely. I mean, most times that I meet with a client, I, have my own kind of internal process as far as the things that I'm looking for, assessing, as you said, to kind of a mini mental status exam of sorts. So a person being oriented, as you said, is a component of that, whether or not they're having thoughts of harming themselves, other people, whether or not their thoughts are logical, coherent, things like that.
So did you just sort of relay the whole checklist, or is that just a brief snapshot?
That's just a brief snapshot.
Okay. So could you just walk us through what your general checklist would be when you're communicating with a defendant?
Sure. I would note any kind of observable things. So like, are they disheveled? Are they, as best they can, given the circumstances of being in jail, kind of tending to their hygiene? Is their speech pressured? Is it unusually slow? Sometimes that can be an indicator of like a thought disorder, if they're experiencing what we call thought blocking. Sometimes if people are doing what a kind of a clinical term, being like loose associations, so making connections with things that you or I would not make connections with, or hearing messages from, that you or I are not hearing. So kind of responding to internal stimuli. And what I mean by that is, do they appear to be hearing voices? Those are, the primary things that I'm looking for.
So turning to the trial in this case, was Ms. Vander, I know I'm pointing over here where my table is, but Ms. Vander was seated over here, correct?
Yes.
And so were you?
Yes.
And you were able to personally observe Ms. Vander Ark throughout the trial, correct?
Yes.
So let's start with the first couple of days.
Okay.
Did she have any concerning behaviors on your sort of internal checklist, for lack of a better term, during the first couple days of trial?
No, I would say similar to prior meetings with Ms. Vander Ark and Mr. Johnson, she seemed very engaged. She was frequently taking notes. She would lean over, and communicate with Fred. I'm not privy to what they were discussing because those were often in whispers, but she seemed alert and oriented in all aspects.
Did you converse with her at all during the first few days of the trial?
Yes.
Was there anything remarkable about her conversation that alerted you to a mental impairment?
No.
Now, I do want to jump into the time frame after she testified.
Okay.
Were you present for her testimony?
Yes.
Okay. Did you view, and that was a Thursday, do you recall that it was a Thursday?
Yes.
Okay. Do you know, after court concluded for the day, did you speak to Ms. Vander Ark after the proceedings ended?
I don't remember if it was, I know I did on Friday. I don't know if I did on Thursday after court proceedings finished.
So let's jump to Friday.
Okay.
Did you respond to the jail? Did you go to-
Yes.
And you observed Ms. Vander Ark in the holding cell?
Yes.
Could you tell the court what you saw?
Yes, I was on my way to court when Mr. Johnson contacted me and said that he needed my assistance down in the jail because Ms. Vander Ark was having a difficult time. So when I arrived, he was already in the holding cell with her, and she was very distressed. She did not want to go upstairs and repeatedly said that she couldn't do it. And Mr. Johnson and I repeatedly, we tried, I mean, kind of, I guess, every way we could think of to try to provide the support that she would need to go upstairs. So I don't know how much detail you want me to.
So let's unravel this a little bit. So Mr. Johnson was actively attempting to get her to come to court.
Yes.
And you were assisting him on that?
Yes.
And it was your testimony that she did not want to come up to court. Is that correct?
Correct.
Did she say it in those words that she didn't want to come?
I don't know. I'm sorry.
Was she experiencing any psychosis?
She did not appear to be experiencing psychosis. I would say that she appeared to be very anxious.
How was her speech?
It was, I would say, pressured, but kind of like going back to those pieces that I touched on earlier, although pressured, it was still logical. It was relevant to the topic at hand. She wasn't making those loose associations. So I would say again that pressured speech would be consistent with anxiety.
Was she oriented?
Yes.
Okay, meaning she knew who she was and where she was at.
Absolutely.
And from her conversations or her statements, she knew what was upstairs, which was a trial.
Correct.
Did she appear to understand sort of what would occur at the trial?
Yes. Yes.
So she understood that there'd be additional witnesses.
Correct.
In sort of the court process.
Yes.
So she wasn't delusional.
No.
She wasn't catatonic.
No.
And what, when I say catatonic, what do you take catatonic to mean?
The most kind of classic catatonia presentation is one that is withdrawn. So in that particular presentation, oftentimes people are not responsive to communication. They might not even be responsive to touch or painful stimuli. They often are not eating, they're not drinking, they are kind of in a stupor.
Did you see any of those signs with Ms. Vander Ark on that day?
No.
Were you present for any discussions about Ms. Vander Ark waiving her right to appear at court?
Yes.
Did you tell the court what those discussions were?
When we were in the holding cell and there was a great deal of back and forth, I would say. At times, Mr. Johnson would leave to, I believe, go upstairs and communicate with those who are up here, whether in chambers, about the status of Ms. Vander Ark, that she was having a difficult time. He would return, and eventually it was my understanding that, you know, since it became apparent she was not going to come upstairs to court, that she could waive that participation. And so that was explained to her. I could not tell you, I guess, the exact language that Fred used. Mr. Johnson. Yes.
But there was discussion of that.
Yes.
And were you aware that she filled out an affidavit or a signed document of some sort regarding her waiving her presence in court?
I guess I don't remember that exactly, no.
But you do specifically remember Mr. Johnson explaining that to her?
Yes.
What was her response?
that is what she wanted to do.
Did she vacillate at all on that, or was she clear?
She was clear.
Did she give any further commentary on it?
If anything, I would say that she seemed appreciative because she very much did not want to go upstairs. So she felt, or it appeared as though she felt relieved by that option.
So if there's a claim now that she never waived her right to not come up to court, is that accurate?
No, as I said, I cannot recall seeing her sign an affidavit. I do remember it being explained to her, though, that this is what she would be opting to do, and that she verbally said that, yes, that's what she would like to do.
Did you see anybody pressure her into that choice?
No, it was quite the opposite. I feel like we were putting as much pressure as we possibly could to encourage her to come upstairs.
Thank you. I have nothing further.
All right, Mr. Ambrose.
Did you say that you were on the call with Dr. King?
Yes.
And you're part of the Muskegon County Defender's Office?
Correct.
Your involvement with Ms. Vander Ark and Mr. Johnson, more or less working together as a team? Is that an accurate assessment? Okay. Did you view Dr. King's evaluation?
I'm sorry?
Did you review Dr. King's written evaluation?
Yes.
And in his evaluation, do you recall him stating that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
Yes.
On December 15th, what was your observation of Ms. Vander Ark? I mean, where was she when you first observed her?
Was December 15th Friday?
That final day of trial.
Thank you. When I first arrived, she was in the holding cell with Mr. Johnson.
What was her physically where was she? Was in the holding cell, but how was she? Was she in a chair? Was she laying down? What was her condition?
I believe that she was sitting in a chair, and if I may, I believe she was sitting kind of with her knees drawn into her chest.
Okay. Did you appear after Mr. Johnson?
Correct.
Okay, and so he was already in there with her?
Yes.
Did you ever request that she be seen by any medical personnel?
No.
You mentioned her speech was pressured. Can you elaborate a little bit on that?
Sure. When I say pressured speech, I primarily mean that it was kind of a rapid pace. I would say that's what I mean, is that she was speaking very quickly.
I have nothing further. Thank you.
Wes.
Why is it that you didn't request medical on December 15th of 2023?
From my perspective, it didn't appear to be a medical crisis in nature. She wasn't expressing medical concerns, wasn't expressing, pain, anything of that nature. It seemed to be more, as I mentioned earlier, kind of anxiety related.
Do you think that the Did it appear to you that it was sort of related to the situation of the
Definitely.
trial?
Yes.
Okay. So there wasn't an actual medical issue that you were concerned about?
No.
Thank you. I have nothing further.
Mr. Ambrose, any follow-up?
You're not a medical doctor.
I'm not.
And, yeah, I have nothing further.
May this witness be excused, Ms. Bloomquist?
Yes, Your Honor.
Mr. Ambrose, may the witness be excused?
Yes.
All right. Thank you, Ms. Cotetti. You can sit down. Does anybody need to take a break right now?
I'm at the court.
Why don't we take a 15-minute break just in case Ms. Vander Ark needs a break, and then we'll be back here at 2:30.
Thank you.
We're in recess.
Oh, thank you so much, Marilda. Welcome to all the new members. Yay! That was like the perfect time for a break, right? You know, we got to let our girl get her, she over there, as much as she's shaking her head, that's why she got a headache. That's why her head hurt, because she doing too much head shaking over there. My head hurt for her. Hey, crazy. Let's go crazy. That make me want to do like Prince. Yeah, she probably won't testify today. It looks like they just gonna take witnesses in the prosecution's case out of order, in order to get to, you know, for the people that's there. He said they'll be back at what time? 2:30. She got your mama. Your mama. Well, hopefully our new chatters, they'll come on over here and hang out with us, right, gang? Or maybe they lurking. You know, we get some people that's lurking. You know, they be lurking. They be lurking. They be lurking. So just so we all clear, like, even though she may be guilty, remember, we have to make sure. You say it make you furious every time you see her take a drink of dang old water. Oh God. Well, you know, and I remember watching this trial, guys. And what I can say is I know that it was because it was her and her son that was doing this to her other son. I can't remember, and y'all can put in the chat, not to say that it makes a difference, you know. Was she doing this because he had a disability, or I can't remember. Not to say any reason is right now. I'm not saying that, so I don't want anybody to get that part twisted. But I just want to kind of remember, you know, we run through so many trials. We go through so many trials. I started condensing trials to be all in one and mixing it all up. Okay, you say he was on the spectrum? Okay. But it's to my understanding, like, she was fighting for custody to get him from the dad or somebody else, right? Like, why you just didn't I just want to make sure that even if people are guilty, I want them to be guilty the right way. It may sound like it almost sounds like oxymoron in a way. Like, if you guilty, of course, I want you, 6 feet up under the jail. Like, read what you saw, do your thing. But in the same thing, you say Holly Bobo, Holly Boo Boo. Not Bobo, Boo Boo is on Tubi. What's she doing on Tubi? What they doing on Tubi, Frank? He said Holly Boo Boo on Tubi, y'all. What they doing on Tubi? Really? Holly Boo Boo. The Bobo case. I have to check that out. Y'all see that? Frank said that the Holly I'm gonna say Holly Bobo. It's Holly Bobo case. I'm about to be calling her Boo Boo. A monster? Yeah, you can call her a monster. You might hear me call her a hoe every now and again, so I don't know. Look. I might call her a hoe every now and again. I don't know. A thug. I would call her any kind of name. Like, you can call her anything. Well, I don't care. Yeah. No harm, no foul here. What we try to do is not try. You'll say whatever she called. Like, I just try not to, when we have victims, we don't want to, call them out of their name. But yeah, you can call her a monster, sure. Call her a hoe, call her a bimbo. I don't care. Like, that's the least of her worries is what we calling her over here at Taking the Trial. She got deeper issues than that. So how did y'all like in regards to oh no, you fine here with that. I appreciate that. I really do appreciate you asking. No, you're fine. So I guess my question to you guys is that we know that we are currently in the midst of watching a post-conviction type appeal with Zach Adams, right? Over there in Tennessee. So we over in Tennessee and we watching that. Have you noticed that this judge is handling this a lot different, where he's asking the attorneys questions and things like that? Like the judge in the last one didn't ask any questions. Is it just me? I mean, I like how this judge is asking questions. I think that from the statement earlier with the judge, like she's sitting up here complaining about her head every 5 minutes. All of this stuff, like the judge don't even believe her, calling cap. Get your lying ass out of here. Like he get the fuck. Like he's not about to waste my time with this stuff. Do that worry y'all? I mean, I know everybody want to see her in jail, right? But my question is like, is she doomed already, considering that the judge does not already believe her? Like, I find it very concerning in so many ways. He like, yo, lying ass, I find it very concerning that you telling everybody that you passed out. You trying to insinuate this on your lawyer. You trying to mislead your lawyer. I don't have a clue why. And this is the judge that you're going to for your appeal. Does that seem a little funny? Like, I mean, it is like you messing with the wrong person. And then she get her old sorry sap ass on the stand. she gets just get up on the stand and tell them how bad she feel today. And I'm like, no, she cannot be playing like she want to puke in a garbage can. She cannot do any of that stuff right now. She got to go all the way in, 10 toes down. Just fall the fuck out. Fall out. She got to really do it. Like, she can't do nothing. She can't tell nobody. She can't express it. All she could do is fall out. So when she was on lunch, she should have been trying to do something. I don't know what to make it happen. Like, we don't believe nothing. Like, she has to, in order for this to go and change in her favor, I think that she done made the judge upset with all this bull crap that she keep doing. And all she can do at this point in time is fall all the way the fuck out. Boom. That's all I got for you. That's all she can do. Yeah, she wasn't voicing that before she left her cell. She just got to the place and didn't want to do nothing today. So all she can do is fall out. Because at this point in time, the judge don't even believe that she's sick, and then she's sitting over there with all that shaking of her head, like she's talking with her neck, right? So we get into talks with her neck and her face. Then you get up on the stand talking about how I just feel so horrible today. Like, girl, okay, come on. Come on. She should have got up on this stand and started having convulsions. She should have just started shaking and just fell the fuck. Like, that was her perfect opportunity. Like Eminem said, you got one shot, and she blew it. So now we're here. She got the afternoon to still try this. But once the judge then told you, like, he feel that you misleading and you like playing on everybody, the judge is the person that's going to be making this decision. So if he can see through this, how do you get on the stand and say, hey, my lawyer did not tell me this. My lawyer did not do this, when the judge has already have in his mind that you are not credible. I mean, you up here lying about your health. He don't understand why, but that's something that you're doing, and he didn't peep game. I believe it, DMB. You know, I watched the trial too. I just can't we watched so many. I don't think got all the facts mixed up. So I ain't gonna speak too much on it. I do remember her with these old I'm gonna call them porn star braids, because that's all I can think of when I look at her. Corn star points, whatever y'all want to do for the YouTube thing. But that's what she looked like to me, because she's too old to be having those two little French braids like that. But that's just my personal thing. Yeah, that's why, her complaining about her head, like getting on the stand talking about my neck, my back. Shoot, this ain't Khalees. Like, this is not what we doing here. My neck, my back. Shit. Don't nobody care about your neck and your back. Y'all know I be having many and plenty of things to say. I be trying not to cut into the testimony too much, but when I be seeing this stuff, I be back here, boy, oh boy. Oh, I have to cut off my camera sometime, because I'm like her. My facial expressions is something else. Like, it's gonna be written all over my face. Like the Rude Boys, it's written all over your face. Oh, it'd be written all over my face. I ain't even gotta say a word. That's what they say. That's what they say. Don't pass out. It is what it is. This is real. This is real. You say the dumpster juice. Oh gosh, not on a hot AZ day. Ew. SD, I cannot. Really, really, really. Like, she just said, but this is the thing. And what bothers me about when we are watching these trials and when we're doing this, I know we don't have a perfect justice system, right? But it's heartbreaking for family, friends, people that had to testify. Time goes past, right? People forget things, whatever the case may be. I just really wish we could get it, kind of right. So that way we won't have these incidents, like this. Because we all know that she's guilty, right? But we got to make sure that I want guilty people to be guilty. State proves it, right? And that they're given a fair trial. As long as all that stuff happened, I'm good. My problem is like when we get to incidents like this where a right has been violated or something wasn't properly given to the person, or maybe they wanted to take a plea deal, or not a plea deal, but maybe some different factors that was not presented to the person. And I just think that if we're going to be out here, throwing people away for life, not to say that she doesn't deserve life, we got to do it right. Yeah, that's why I said that with with the judge saying that she he thinks she faking it now. She ain't got no choice but to fall out. Shoot, give us that content. I mean, come on, Shanda, girl, give us that content. Like, go viral, do something. She need to fall all the way out. She got to make it real. Hey, Ruth, how are you, honey? I'm glad you were able to join us. Yes, I just think that she really needs to she need to go for the gusto. She got one shot. She got one shot to make this happen. When she got on that stand and she told the judge that she wasn't feeling well, she should have fell all the way the fuck out. I'm trying to tell you. We got to get our curriculum for our Take It to Trial Fall Out class. We do have one for the cry class. So if you know any defendants out here that are willing and want to take the stand, please make sure that they check into the Take It to Trial cry class. And we are not going to be implementing a curriculum for people that need to fall out. It's certain times that you do definitely need to fall out in court. Like, just fall out. If you need to stop the proceedings and it's that drastic and it means that much, I do want you to fall out. Yes, I do want you to fall out, and I'm good with that. But I want you to do it. I want you to do it. Now, I don't want you to stop. I want you to get it all the way in. Make me a believer. I'm telling you, that judge couldn't have told me that. Soon as that judge would have told me that, I probably would have fell all the way out. If it was nothing but me having a temper tantrum, court would have stopped that day. Oh, it would have stopped. They would have been like, "Oh, take her back to her cell." Because she is way out here. She is out here on a planet by herself. You say she come up with more excuses than anybody. And everybody peeped the game. Everybody peeping this game. She ain't fooling nobody. That's why I said the last thing that she could have did was fall all the way out. But yeah, well, she gonna beat around the bush about what happened to her baby during that period of time. But yeah, she needed to pass all the way to like, I don't know. I just feel like if you're gonna do it, you need to do it all the way. Yeah, Marilda, because I feel like if you're gonna do it, I want you to do it. Don't half step this. Like, I'm trying to tell you. But in the future, she'll know for our next one when she come back for a hearing. We would definitely have our Take It to Trial Fallout class. Like, don't talk about it unless you're gonna be about it. Look, we're not gonna talk about it unless you're gonna be about it. And that's it. That's all. That's all we can say. I'm gonna say that to anybody. And it's like, if you're gonna be about that life, be about it. It's like my guy Zach. He got on the stand. He say, "Look, I'm the biggest drug dealer that you ever want to see. Like, I wanted people to be scared of me. Like, he stood 10 toes down on what he is. Like, if you are sick as you say you are, please fall out. Please do something. Don't get up here, after, the judge can see all her interactions. So it just sounds like bull. Because he sees her over there, shaking her head, writing down notes, letting her attorney know this is what they saying. So he sees this interaction. So then for you to get on the thing talking about how you feel so horrible, who the fuck cares? Like, who cares? But I think that the judge is trying to I think the judge is really trying to tread on thin water, because remember, we are here because of ineffective counsel, right? So he doesn't want to see that, We are going back in court, so I'm gonna take us right back in there and see what other shenanigans she gonna have for us this afternoon.
All right, back in the record and People versus Vander Ark, 23110 FC. Ms. Bloomquist, you can call your next witness.
Thank you. And I guess just one matter for the record before I call my next witness. I know I previously said that I had 3 witnesses. There's been another witness that just based off of some discussions outside of the courtroom. I may add a 4th, but I didn't want to catch Mr. Ambrose completely off guard because we discussed witnesses last week. It would be potentially Mr. Roberts. Just for a couple of communications that he was there present for with Mr. Johnson. So I just wanted to alert the court to that since I previously said 3 witnesses.
Okay, Mr. Ambrose.
I'd object, Your Honor. I mean, I'm prepared for 3 and I have to.
Well, let's see what we can get done, and then we'll go from there. So if Mr. Roberts is a potential witness, then I'll have him excuse himself. And so I'm going to reserve a decision at this time on that, see where we're at. I'd like to get as much done as possible.
Your Honor, I anticipate I could be done as early as 3 o'clock.
Okay, all right.
So I call Katie Evans.
Okay. All right, Ms. Evans, just come right on up and raise your right hand to be sworn. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Catherine, Katherini, Evans, Evans.
Go ahead, Ms. Bloomquist.
Where are you currently employed?
The Sheriff's Department, Muskegon County Sheriff's Department,
And what's your current assignment?
Court Sheriff's Deputy.
So you work here in the courthouse, correct?
Yes.
And back a couple years ago, were you assigned to work the trial of the people of the state of Michigan versus Shanda Vander Ark?
Yes.
Okay, and what was your role in that trial?
It was my job to transport her from the jail to the court and then up to the courtroom and then back down.
So specifically drawing your attention to the final day of the trial, do you recall a situation that occurred in the holding cell of the jail?
In the court services area?
Well, I guess, thank you for correcting a poorly worded question. Did you have interactions with Ms. Vander Ark on the morning of December 15th, 2023?
Yes.
Where did those happen?
In the court services area.
Okay. And is that a holding cell of sorts?
There are holding cells, but where we mostly interacted would have been kind of off to the side.
So you did in fact interact with Ms. Vander Ark?
Yes.
Okay. And did you see her have interactions with her attorney, Mr. Johnson?
Yes.
Were you a part of any of those?
I was not.
Okay. Is it pretty standard procedure that once the attorney's there, you're not involved, correct?
Correct.
At some point though, did you have communication with Ms. Vander Ark?
Yes.
And what did she say?
I was putting a taser on her ankle for coming up for court.
Is that standard procedure?
Yes, everyone that's in a jury trial.
Okay. So you're
And-
putting the taser on and
Yep.
then what happens?
And she made a comment to me saying that if she comes up here, she was gonna attempt to run.
Did she appear alert and aware of what was going on around her?
Yes,
Did she know what the taser was being put on for?
yes.
To go to
Because
court,
we've done it
correct?
multiple times throughout that trial.
Okay. And had you been the one personally to put that on her the other days?
I don't recall, but me or Levine.
Okay. But one of you?
Yes.
Would put that on her before court every day of her trial?
Yes.
And this was the last day, correct?
Yes.
And did she appear catatonic?
No.
Did she appear to be conversational?
Yeah. Talked.
Okay. Anything about your conversation with her that made you think that she was having a mental health episode?
No.
Okay. Thank you. I have nothing further for you, Deputy.
All right, Mr. Ambrose.
Was your former name Bassett?
Yes.
Okay. And what was your first encounter with Miss Vander Ark on December 15th, 2023?
Probably when she came down to get dressed for the jury trial.
Okay. And you mentioned that she stated something along the lines of that she would run.
Yes.
Okay. Do you recall preparing any type of report about Miss Vander Ark from December 15th, 2023?
In reference to that situation?
Or any situation?
Not that I recall.
Your Honor, may I have questions? Can you identify that?
Yes.
What is that?
It's a report that was done by the jail.
And your name's on it, correct?
Correct.
Deputy Bassett.
Yes.
And in this report, there was a remark about her being, Miss Vander Ark being suicidal.
Correct.
And is there anything in there about her stating that she was going to run?
No, because this more than likely would have happened after the whole situation.
Okay.
And I did not type that report.
Okay. Fine. But you were there.
I assisted the jail in a situation because you need 2 females.
Okay. And she was placed in a suicidal note.
Yes.
That seems to me a pretty drastic situation.
Correct.
Nothing further.
Mr. Quist.
I have no follow-up.
Deputy Evans, how many times were you working through most of the trial for Miss Vander Ark?
If I recall, I was here every day.
Okay. Did you have a chance to observe Mr. Johnson with Miss Vander Ark? I mean, whether it be in passing or even up in the court area, anything like that?
There was a few times where I had transported Vander Ark and Mr. Johnson down the elevator to the jail, and then that way they could talk in private.
And when you went down to the jail, were you ever standing outside the room? Did you kind of hold there and just wait until needed to come back up?
No, normally I would go back to like our office, which is like a bubble, and they were kind of on the other side of the glass.
Okay. Did you ever observe them body language of not getting along, being upset with each other, being angry at each other, any arguing, yelling, anything like that?
No, never heard any yelling. I didn't know if it was a while ago, so sorry, but I don't recall any body language or anyone being upset.
So, as far as you didn't observe any behavior would indicate that Miss Vander Ark and Mr. Johnson were having some sort of disagreement or argument.
I didn't see anything.
Any follow-up to that, Mr. Ambrose?
No.
Mrs. Bloomquist?
None, Your Honor.
All right, may this witness be excused,
Yes.
Ms. Bloomquist? Mr. Ambrose?
Yes.
All right, you can stay down, Deputy. Thank you.
Thank you.
All right, you can call your next witness.
The people call Deputy Tim Levine.
All right.
Yeah. It's more important information.
was just using. Right on up front here. And please raise your right hand to be sworn. This matter not pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Tim Levine, Timlavigne.
Go ahead, Ms. Bloomquist.
Right, good afternoon, Deputy. How are you?
Good afternoon.
So where are you currently employed?
Muskegon County Sheriff's Department.
How long have you been employed there?
Oh, probably 14 here.
Okay, and what's your current assignment?
I'm with the Court Services Division.
And back in 2023, were you also assigned to court services?
I was.
Okay, and were you specifically assigned to assist at certain points in the Shanda Vander Ark trial?
I was accompanying her up here for the trial.
Okay, so you would assist in transporting her from the jail to the courtroom?
Correct.
And specifically drawing your attention to the last day of trial, which would be December 15th of 2023. Do you recall a situation that occurred in the court services holding area?
I do.
Okay, could you describe what happened to the judge?
Well, I believe she was refusing to come up here during the trial at some point. And we decided that we would have a form made up that she was refusing to come up here. And I had our court services secretary draft a little form for her to sign. And I took it to her along with my secretary, notary public, in the holding area of the jail, where I found her, her attorney, Fred Johnson, and I believe a social worker in the cell together talking.
And so she had multiple people there with her at that time, is that correct?
That's correct.
And did she, in fact, sign the document?
She did.
And how was her demeanor while she signed it?
She seemed fine to me. If I remember right, I believe her and her attorney were just sitting on the floor next to each other talking.
Did anybody force her to sign this form?
No,
Did anybody threaten her that you saw or heard?
no, that's the exact purpose of the form that we had made up.
Did she appear to understand what the form meant?
Yes,
And it's your testimony her attorney was there with her.
correct.
Do you recall any conversations that her and Mr. Johnson had that you heard?
No, I didn't. No.
Is that pretty standard that you wouldn't be present for attorney-client communications?
Right,
Protocol?
correct.
Okay. Now, I know you answered this already, but you didn't threaten her to sign this.
No,
So I'm showing you what's been pre-marked as People's Proposed Exhibit 3. Could you identify what that document is for the record?
yes, this is the form that our secretary typed up and I presented to her. She signed it, I signed it, and our secretary signed it.
Your Honor, at this point in time, the people would move to admit People's Exhibit 3. I would also note that this has been in the court record as Court's Exhibit number 1.
Oh, okay. Mr.
No
Ambrose?
objection.
All right, it's admitted, so this is Exhibit 3 for today's purposes. Admitted without objection.
And Your Honor, if I may publish.
Me. Thank you.
Deputy Levine, based on anything you observed with Ms. Vander Ark on that morning, was there a medical emergency that occurred?
Not that I recall.
And did Ms. Vander Ark make any comments to you about coming to court?
Other than she didn't want to come to court, no.
Okay, you heard her say that?
Well, yeah, that's why we were there.
Thank you. I have nothing further, but Mr. Ambrose will have a couple questions.
All right, Mr. Ambrose.
You mentioned that Ms. Vander Ark and Mr. Johnson were talking to each other.
Yes, in the cell, in the holding cell.
In a holding cell. Can you describe for me and for the court what the holding cell consists of?
This one particularly was a cell that there's no chairs. It's just a very small, single occupant cell. I mean, 5 feet wide, 7, 8 feet deep, and they were sitting on the floor. There's just a mat on the floor. That's where they have to sleep.
Okay. Was there, were you there with Deputy Bassett at the time? Her name was Bassett. Now it's Evans.
Well, I've been around her throughout the trial. I don't specifically recall if she was standing next to me or not. I know our secretary was with me.
Who is Sergeant Vanderland?
He is a jail supervisor.
Were you aware that Ms. Vander Ark made her comment that she was suicidal?
Not to me. I don't know anything about that.
Did you ever observe her in a suicidal event?
I have.
Was that on that day?
I do not recall if it was that day, but I've had to bring her to court numerous times, and I think she's been in and out of them.
Was there any request made by yourself or anybody that you're aware of that requested any type of medical assistance for Ms. Vander Ark?
I think some of our deputies have in the past.
On that particular day of December 15th, do you recall?
I do not recall if she needed medical help that day.
Okay, no further question, Your Honor. Thank you.
Just a couple briefly that I apologize, I missed these out direct. Deputy Levine, are you aware of the video recording capabilities of the jail? That there are cameras?
Correct.
And unfortunately, is it true that there are no videos of the holding cell currently due to time constraints?
Correct. Once I was subpoenaed for this, I asked to see it, and apparently they only hold the data for 30 days if it's not requested.
Thank you. I have no further questions.
Mr. Ambrose?
Nothing further, Your Honor.
Deputy, whose idea was it to draft Exhibit 3?
I believe it was mine.
Okay, all right. When it was presented to Ms. Vander Ark, were you present? So my question is, did you walk in the room with the form, hand it to Mr. Johnson, and then she signed it? Is that what happened?
Yes.
Essentially? Okay. Did Mr. Johnson or Ms. Vander Ark ask for privacy to discuss the form?
I don't believe so.
Prior to the drafting of this, did you speak to Mr. Johnson? Hey, listen, you want us to type up this form or something, or was it more, hey, here's this? I mean, did he have any part in the idea to draft it or not draft it?
No, because I had it drafted before I got into the jail where she was being held.
Can you tell me why that you had the idea to draft this? I mean, what was the motivation behind?
Well, mine is so I wouldn't have to appear later to say I coerced her into saying something that I didn't want to go. I just, here, sign this, and
Okay.
I would bring it up to the attorneys.
In all your, I mean, I'm assuming that while you were bringing people up and down, did you have an opportunity to see Mr. Johnson interact with Ms. Vander Ark?
Yes.
In transport or either up here or those kind of things?
Yes.
At any point in time, did they seem to be, just in terms of body language or things, maybe voices, did they seem to be arguing with each other or be upset with each other or having any disagreements with each other?
No, never seen anything like that.
All right. Seem to be getting along okay?
Correct.
All right. Including the last day of trial when he was talking to her in the holding cell?
Yeah, again, I'm in the area. I don't listen to what goes on, but no, I've never heard any outbursts, if that's what you're asking her.
Any follow-up to that, Mr. Ambrose? Or I should say, I think it was Mrs. Bloomquist. Any other follow-up, Ms. Bloomquist?
No, Your Honor.
All right, Mr. Ambrose, anything?
No, thank you.
All right. May this witness be excused?
Yes.
And Mr. Ambrose, may this witness be excused?
Yes.
All right, thank you, Deputy. Okay, well, that brings us to the matter of Mr. Roberts. Just in terms of, just as an offer of proof, Ms. Bloomquist, what is he potentially going to testify to?
Thank you, Your Honor. Yes, it's my understanding and my anticipation is testimony that he has some testimony about some in-chambers discussions that occurred about the involuntary manslaughter instruction, as well as the commentary as opposed to admitting the entire video, as well as, I was unaware of this until just a few moments ago. Apparently, Mr. Roberts and Mr. Johnson went and spoke to jurors after the conclusion of the trial, and there was one juror who I believe was hesitant and took a little longer to convict, and her purpose for that was apparently to give credit to Mr. Johnson's strategy and theory of the case and arguments that he made. So I think as it relates to the soundness of Mr. Johnson's strategy, I think that's pertinent evidence.
All right, Mr. Ambrose, are you objecting to the testimony itself, or just now it's being sprung on you right now, or?
I mean, I would like to review the transcripts and prepare a little bit better than just being sprung on.
And I will say, Your Honor, it was not my intent to spring it. It's
No,
just that
no,
it came up in a conversation naturally, and then I was like,
I'm just in my head contemplating what kind of prep work. I mean, I don't, there's no transcripts of anything discussed in chambers. There's no transcripts of anything to talk to a juror. I mean, I suppose the only way I guess you prepare Mr. Ambrose would be to question Mr. Roberts, or at least because he's a witness, essentially given an opportunity to talk to him. I mean, is there anything other prep work you would do? I mean, I'm just trying to figure out what would the additional time yield for you in terms of preparation, just for that testimony. It just seems like there's nothing. If this was another witness who had testified previously at another hearing or had made other statements to the police, or I'm just trying to figure out what the time would be needed for, besides just general kind of catching your breath kind of thing. So
I like to prepare.
Yeah.
And, I walk into these types of hearings with a set of, an outline of what I'm going to, points I'm going to make and so forth. And off the top of my head, I have a few questions I can ask them, but knowing ahead of time, I could probably do a better job at that.
Okay.
And I think we're going to come back anyways, and that'll give me enough time to think about it.
All right. Well, okay. So this is where the court's at. I mean, it's 3:00. We do have another 2 hours potentially. I am ready to go in terms of testimony. Okay. Mr. Ambrose, is my understanding that your client, and like I said, I don't want this to come up later saying that this thing is being delayed. I'm ready to take testimony. So if she's saying I can't do it today, and are you still requesting an adjournment to allow her to be in better health prior to testimony?
I am.
Okay. All right. Ms. Vander Ark, is that your decision?
Yes.
All right. All right. Anything else, Ms. Bloomquist?
no, Your Honor.
All right. Well, we'll adjourn for today. And then Mr. Roberts hopefully will make himself available to Mr. Ambrose if he has any questions, as any other potential witness should. He obviously doesn't have to, but if he can, that would be good. And we will schedule this for another date, hopefully sooner rather than later. My preference is going to be sooner, so hopefully we can get this done. Anything else before we adjourn, Ms. Bloomquist?
No, Your Honor. Thank you.
Mr. Ambrose?
No, I appreciate it. Thank you.
All right. I'm assuming, Mr. Ambrose, your client wishes to be here in person at the next hearing. Is that correct?
Yes. Correct.
All right. All right. All right. We're adjourned for today. Thank you.
Talk about she was gonna run. Can you imagine, man? That would be so funny. Like, you know how they saying they put that little shock thing on her for her to be running, and they shock her, and oh gosh, oh wow, she should have just ran right there. I want her to run now. I don't even want her to follow. I want her to run. Let's see. So we got to keep our eye out because, of course, they gotta come back. The judge don't sound like he happy about having to come back, but they're gonna have to come back for that one. So I'll have to keep an eye out on regards to when they have the next one. She's sitting over here. They still talking her attorney. They still got the court feed up there. We can't read lips, so I don't know what they talking about. So I think that what we'll do for the remainder of our day is we will continue to go. We'll go back to our Samantha Cribs. Let's see how Crabs, whatever y'all want to call her. Krabby Patty. We'll see how much time Krabby Patty gets. So we'll go back into that courtroom. And I am going to put on our schedule, we are going to watch the Thanksgiving Eve redrum trial tomorrow. It is probably about it's like a 5-hour trial. So we'll watch that one tomorrow. So we will do that. For tomorrow, we'll probably still start at our normal time and stuff. Oh, that sounds good. Cooking for the rest of the day? Yeah, we'll probably go over there and see about day 4, the rest of that. Once I want to go ahead and I guess we'll finish up our Krabby Patty. Y'all want to finish up Krabby Patty? Because I don't know what she got yet. I don't know what she got, but let me see how much more time we got. It looked like we own 1.5, so we are speeding it up. I just don't know how much. I don't know how much time we got left. I don't think it's really that much. So yeah, let's finish up Krabby Patty only because I don't know how much time she got. If you've seen it before, please just hold your horses because we don't know. At least I don't know. So don't spoil it for me because I want to see. And let's see what Krabby Patty get. I got it on 1.5, so we should be able to get through it pretty fast, guys.
There's not blood on the wall. She says she buzzes them in. There should be blood. If she is helping trying to stop that blood, there should be blood all over on her or around her. She says when she testifies that he's gushing blood. Now, that's not really super consistent with what Dr. Kelly says because Dr. Kelly said so much of that blood was in that heart sac, but yet still in the beginning that some blood would certainly be present. But she's talking about it gushing. She talks about trying to let John Pfeffer in. She has him as soon as he comes in, a guy with as much criminal history as he has, somebody who some might say was a quote unquote hardened criminal and has had lots of prior law enforcement contacts and times in custody. His first response was the need to call for 911. Now, up to that point, that would have happened within minutes that he would have stabbed. At that point in time, she's not doing anything noticeable. According to Christy, she's standing over him. At some point, Christy takes over. Christy has blood on her when she's rendering aid, some on her clothing and on her hands. And at that point, Samantha's primary concern is her. She would burn the world to save herself. And she starts. And she tells John, whose immediate response with all of that experience he has is we need to call 911, who is not law enforcement friendly. He doesn't want all of those people there. He doesn't want to have contact, but he knows that that person laying on the floor needs medical help. And she says, no, wait a minute. Now, I think there's a lot of conversation. There was a lot of testimony about what else could have been said. It could have referred to other things. I don't believe that. When I listened to that call and I listened to it, I don't even know how many times. To me, it is very clear that she's saying not to call 911. Because if She wanted 911 called. At some point, she'd say, hurry up and call 911. Somebody in that situation is not going to respond by just letting it be, by going through the house and clearing the house of any drug paraphernalia, by getting whatever she needed in order to be able to leave. And we think about that closing argument, and we think about that painful, painful time of listening to that call and sitting and watching that video and waiting for her to turn on Northland. All of those minutes where someone should have called for help. Certainly the person who caused it should have called. Certainly the person who loved him and wanted to marry him and wanted to be a stepmother to his child and wanted a future with him should have called. She could have called and still gotten out of there and gone to Jeff Hayes' apartment. She could have called and just skedaddled. She could have called on her way, but she didn't. The first person she calls is she's calling Jeff Hayes. She's talking to John Pfeffer. She's not actually engaging in anything that would get help to Joey. And that wait and the silence and the clock ticking away while no aid is rendering is her watching the world burn while she leaves to save herself. She put so much effort in to avoiding apprehension. She talked about how, what are we supposed to say? He fell on a knife, then it's suicide. Is she there? Sometimes she says she's there. Sometimes she says she's not there. She can't create the truth because the truth to her is a constantly moving target because she has to create the story. So then we have that call with her when she could have offered up some help. She could have come back when she was talking to Officer Felmer. And again, just the continued, like he was manic, he was acting crazy. He was doing all of these things that essentially muddy up Joey to try to make it about him while she's trying to avoid any apprehension. The hiding, the changes in behaviors we saw at Jeff's apartment on the videos, getting rid of clothes. If they were in the hamper, law enforcement would have found them when they did the search warrant. Those clothes, I don't know when they left that apartment, but they were gone because she didn't want to be connected to them. That apartment, not big. They didn't just disappear on their own, and they certainly weren't in the hamper. The call to Joey's voicemail the next day suggesting he was at work and her saying that, well, I thought maybe he would be at work when she was talking just before in her testimony about how he's gushing blood and he was visibly dying before her. And then this cover up to have this fake text message that she's concerned about him. The covering up of the VIN number to suggest that she didn't know that was happening and that was all Jeff Hayes' independent plan, or her phone being deleted and going to John Pfeffer and that all of her phone getting erased to cover up what she had been doing, the stickers on her vehicle. She is the one that's commenting to her mom in a phone call about her vehicle not having stickers. So it's not going to be the one that we saw in the video. The calls to her mom are so interesting because her mom is so confused. And you can hear it in there when her mom is continually like trying to keep her eye on the ball and the ball keeps changing because the story keeps changing. And her mom's like, well, I thought that's not, nope, that's what happened. Because she kept trying to cover for herself. When we talk about this, and I know that the court heard all of the testimony, but I think it's important.
Tilly, oh my goodness. I'm stopping this only because I shit you not, guys. Okay, wait a minute. I might be able to predict lottery numbers because I was just sitting here thinking I probably need to email Tilly. What was I doing? And then you come pop up in the chat. Girl, I need to go play a number. I might have them capabilities and don't know. I'm telling you, I was just sitting here and I was like, okay, I need to email Tilly because I haven't seen her in the chat in a couple days. And I know we wasn't gonna be here on here that much longer. And then you just popped up in the damn chat. Oh, I'm taking my talents to South Beach. I don't know what y'all doing around here. Oh my goodness. I cannot believe it. I'm telling you. I might have a gift. Oh my goodness. I am going into the bathroom. You're right. You right there because I'm going into the bathroom and I am about to do some gifting because I cannot believe this shit. I'm telling y'all, I was just sitting here and I was like, if I tell them, they're not going to even believe me, but I got to tell them because that's what the hell I was just thinking. And then I just looked up and she was in the chat. That's why I had to stop the damn thing. Oh, man. Oh, I'm going to play some numbers. Let me think of some numbers right quick. All right, guys. Here y'all go. Sorry, I had to. Oh, my goodness. That warms my heart.
Important because one of the galleon factors is, does she take accountability? Does she have remorse? That's something the court has to consider. And the reflection of all of this is none of that exists. But it goes on and on. She changed her testimony she changed her story during testimony constantly. It was you would address one thing, you go on to the next, and it would contradict what we had just talked about. She has zero accountability. In the PSI, she continues to maintain her innocence. Her actions and statements since the incident have been entirely self-serving. She's consistently making things up on the phone calls. She's consistently making things up in terms of evidence and in terms of facts, in terms of her testimony. It was absolutely incredulous. But then she's dragging others in to help her cover it up. At trial, I know that the defense idea was that these men did whatever they could to help her out. These men were pawns in her game. They are manipulated. She manipulated Joey. She manipulated Jeff Hayes. She manipulated John Pfeffer. She manipulates Greg Allen to get what she wants. And she talked about that. In fact, on cross, or redirect, I think it was asked of her why she was talking to Greg Allen like that in those phone calls. And it was to get money, so that she had access to money. She wanted the best iPhone 15, whatever, that came out last year, that Greg Allen was going to buy her. Just using him for money. Those sexual conversations that she had on voicemail, whatever she needed to do was what she was going to do to get what she in fact needed. And that's the same thing we have with Jeff Hayes. Now, they have their own role. They have their own accountability. They can make their own decisions, and they did. But that's resulted in John Pfeffer having sentencing next week for harboring and aiding a felon. It will have consequences for others. It has consequences for her. She will pull whatever she needs from people. She will say whatever she needs to say to people in order to be able to get what she needs. She isn't an 18-year-old naive person. She is an experienced individual. She at that time was a 38-year-old woman. She was independent. She had tons of contact with law enforcement and with the criminal justice system. She was not naive to this process at all. And she didn't need protection. Their involvement, the men, wasn't protection. It was manipulation. They tried to protect her because they had some version of love interest from her, which is how she uses her manipulation tactics. But we can see that time and time again through these relationships and through the actions that they had taken after Joey had been stabbed. I know that the court listened attentively to all of the testimony, and there's so many things that, as I reflected for sentencing, to point out that are just so impactful from my standpoint, from my view, in terms of how she manipulated people, how she got what she wanted, how she tried to manipulate the court system, even in that phone call with her mom about what diagnoses they wanted to come up with Joey, and then how they should be able to communicate that back so that we're using that after we were already in the court process. There's so many things, but I know the court paid attention. I know the court listened attentively, and I don't want to rehash all of those hours and days of testimony, but those are just some of the highlights, and there's so many more. My concern is, in the days after the homicide, what is so indicative to me of her lack of remorse and her lack of accountability are those jail calls, the laughing and cackling about who doesn't stab their boyfriend. I don't see in what world any of that could possibly be funny. When she is having those sexual conversations with Greg Allen, when she is having those conversations with Jeff Hayes about John Pfeffer, about him, all of those conversations, there is no remorse. She supposedly just lost, in her version, to suicide. She just lost the love of her life, the person she was married, the person she had just set a wedding date with, the person she said she wanted to be a stepmom for. She had lost that love. And we saw those messages of how much Joy loved her. And within days, it's like it never happened. In days, she's moved on. In days, she's looking for who's going to help her out next. Greg Allen, Jeff Hayes, John Pfeffer. Who's going to help me? So when I'm looking at what the right sentence is, I'm looking for some glimmer that if the court grants her eligibility for release, that she's going to come back into this community and she's going to live a law-abiding life. But then I look at her behavior in court, and I looked at all the times that she would manipulate the emotion, in my opinion, and cry at certain times and not at all. And the way she responded and acted, her body language, I don't think there's any remorse there at all. There's no conversation in here, even if she wants to maintain her innocence, which that's the role she's taking. If she wants to maintain her innocence, there is absolutely nothing in this PSI about, oh my God, the love of my life, the guy I wanted to marry, he died. And I am so sad, and I am so devastated. If she wants to stick to her story, or one of them, that he fell in a life or he died by suicide, there should be tragedy in here. There should be heartbreak, like we heard from them, because that's the person that she wanted to choose to spend the rest of her life with. So if the court grants her release, she was 38 when she was taken into custody. Joey died in his 30s. So even if the court gave her 30s or 40s, say she gets out when she's in her early 70s or her early 80s, what is it in here in the PSI that tells us that she's going to live a life free of crime and not hurt somebody else, not manipulate somebody else? How is she going to change her actions? And I looked for that, because While I can completely appreciate the family's request for a life without release, it makes complete sense to me as a mom, a grandma, a sister. I get it. But my job's to do the right thing. My job's to serve the community, not just echo what they say. So when Attorney Grody and I sat down, we were talking through this, we're looking, what is it that's going to tell us that when she gets out, she's not going to manipulate another man? She's not going to look for somebody when she gets out of prison and has nothing, that somebody isn't going to help her out. She isn't going to be able to manipulate to get whatever it is that she needs. And at that time, she's going to be older. She's not going to have anything. But those people, if they do, will be what we consider by statute vulnerable adults. Greg Allen, he's a vulnerable adult. He made his choices, but he's categorized by that. But those people that she will likely have as her age group will be the people that she will want things from. Because from what I've seen, and the evidence that I have, she's always looking for people who are going to get her something. And so the cycle is going to continue. Someone else is going to be in a relationship with her very quickly after she's released. And she will prey on the men that she needs something from and who have something to offer her. And she'll take advantage of others and use them. When I look at this PSI, I don't see how we're going to change the cycle. I don't see how all of the efforts that have been taking place for the last 20 years, they haven't worked. A trip to Cheetah for a period of time, a placement there, didn't work, didn't change the course of the behavior. And so from a community protection standpoint, the only place that the community is protected from her is when she's in custody. And to me, that looks like a life sentence. Because she has done the ultimate crime that this state has by taking the life intentionally of another, and by her behavior and by her actions after the fact that continuously show a character of a defendant who I don't know how you change that. To give her the empathy and the care to make different choices to not harm other people. So based upon that, I do think that in consideration of all of that, a life sentence is appropriate and that she shouldn't be released. And I'd ask the court to consider and follow that, as well as grant restitution, and any sentence related to this case should run consecutive to any other sentence because it's completely unrelated in my opinion. And I would ask the court to follow that as well. Thank you.
Okay, Ms. Rock, go ahead.
Thank you, Your Honor. In this case, we are asking for a parole eligibility date. I believe that the earliest that date could be is after 20 years, and we would make that request. We are further asking that the sentence in this case be run concurrent to the sentence she is currently serving as part of the revocation. While I do understand that they are two separate matters, I can advise the court that the reason why she was revoked was because of this case. There were no independent allegations that led to the revocation. We are at this time making a request for a restitution hearing, primarily because we just received that documentation yesterday and still need time to review all of the numbers. So at this point, we would ask for a hearing to be set in that matter. When we look at the Galleon factors, the first thing that we are to look at is the gravity of the offense. And I acknowledge that the gravity in this case cannot be understated. It is the most serious crime that exists in the state of Wisconsin. I don't want to reiterate a lot of the testimony or facts because that has already been stated here today, and the court has sat through the trial and had an opportunity to listen and observe to all of the testimony and the recordings on its own. The state has talked a lot about a lack of remorse coming from Ms. Krebs, and I simply do not think that that is true. When she's displayed emotion, they say that it's manipulated emotion. So quite frankly, I don't know what they expect a person in her situation to do. Ms. Krebs is incredibly remorseful. She did lose her fiance. There was nothing presented at any point to suggest she had any reason to wish him dead. She was in love with him and she wanted to marry him. Addiction was rampant within that home. It was something that both of the individuals struggled with, Samantha and Mr. Carnot. And while they did take different tracks throughout their addiction, I don't think that we can say that one person did better than the other. Addiction is no joke, and Ms. Krebs has struggled with it for many, many years now. It is true that her addiction started a little later in her life for what the court or the parties in court are somewhat accustomed to seeing. Oftentimes, unfortunately, we see young teenagers becoming addicted to substances and then that continuing for the rest of their lives. But as outlined in the PSI, Ms. Krebs' addiction didn't start until after her high school years, when she was introduced to substances via a family member, unfortunately. But she did struggle with it. And it's a shame that getting over addiction or past addiction isn't as easy as just saying, hey, here are all these resources, take them and get better. It's not that simple. And I think a big factor in whether the utilization of those resources is successful or not is somebody's like mental state and whether they are ready to take their addiction seriously and take their recovery seriously. And unfortunately, sometimes that takes a really traumatic and unfortunate incident for something in that individual's brain to just click and decide that it is time. And in my reading of the pre-sentence investigation report, Ms. Krebs made very genuine statements to the PSI writer with regard to her record, with regard to her struggles with addiction. And it's as if something has clicked for her now. She's made comments that she wishes she had taken things more seriously. And I think that change has really happened in her. And no matter what sentence the court puts forth down today, whether there's an eligibility for parole date or not, or whenever that date is, quite frankly, this period that Ms. Krebs is going to spend incarcerated is going to be her longest period of sobriety that she's ever had. And I think that's incredibly significant.
But there was a lot going on in that house on the night of this incident and even leading up to it. Again, both parties were struggling with addiction. And I just want to point out that it wasn't Ms. Krebs manipulating the court system in any way or the parties in any way when she's talking about mental health issues that Mr. Carnot was struggling with. That wasn't something that was made up. There's documentation regarding that, medical documentation. And that was something that was being dealt with within the home as well. Talking again about there being no remorse, I just don't think that that's true. Ms. Krebs is remorseful. And while she does maintain her innocence in this case, I think importantly, she's respected the process. She's not had any types of inappropriate outbursts at any court proceeding. She's acted appropriately here today and throughout the trial proceedings. She was cooperative meeting with the PSI writer. While she didn't wish to speak about the facts and she relied on her testimony, she was forthcoming about all other information. While she didn't give a statement to law enforcement in this case and she left on the night of the incident, when she did have contact with them, she was always respectful. She was always polite. That is her true character. And when we look at her character, there is so much more to her than what has been portrayed by the state here today or even throughout the trial. She's a loving person. She's a sister. She's a daughter. She's a granddaughter. She's a mother. And that was something she struggled with as well. Unfortunately, again, it's not as easy as saying, hey, here's all these resources, do what you need with them so that you can maintain custody of your daughter. If it was that simple, we'd be living in a completely different world, but that's just not the way that things are. And that's something that Ms. Krebs lives with every single day. And I'm certain in my relationship that I've developed with her, knowing who she is as a person, that if she could go back and change things, she would. But again, unfortunately, sometimes it takes a very serious incident for somebody to be at that spot, to be in a position where they can say, okay, now I really do need to take this seriously. And these are the things that I need to do. And Ms. Krebs is there. She helps her family in their times of need. She helps the ones that she loves. I think that's demonstrated throughout this record. There was testimony about that, and there's evidence of that in the character letters that were submitted on her behalf. I think that's really also outlined in the PSI report itself. Again, Ms. Krebs, I think, was very forthcoming with her record. She didn't try to shy away from the struggles that she's dealt with. The state has indicated that she really has no employment history, but I don't think that's wholly accurate. While it's very limited and lacking in regards, she has maintained employment. A lot of that was disrupted by the periods of times that she did spend in custody. Although she does have that significant record, mostly it all involves around her drug offenses and her drug use. There's a very limited record of any type of significant violence. And again, it stems from this addiction. Looking again, just very briefly at the remorse aspect of this, Attorney Templis has talked about how we've heard these jail calls of Ms. Krebs laughing while she's been in custody, and how if she was truly remorseful about having lost her fiance, we wouldn't hear things like that. But I don't think it's fair for any of us to say that there's only one way that a person can react to a situation like this. And when we couple that with the fact that she is in an environment, in a locked environment, in custody, trying to deal with everything that comes from that, just the power dynamics of all of the individuals involved in that system, I don't think we can say that because we hear 2 or 3 phone calls of her laughing or having any type of sexual conversation that she's not remorseful or that she's not sad that she lost her fiance. There were hundreds and hundreds of phone calls that were provided through the discovery materials, and there's multiple phone calls where Ms. Krebs is emotional and she's crying. Those weren't played and the court didn't have an opportunity to hear them personally or throughout the trial, but those exist. And we can't just ignore that and say, well, she's not remorseful because
They must be loading their video up. Hold on. They must be loading it up. Give me 1 second. Let me see if I can get back in there. Updated today. Okay, let me.
All right, we're back on the. All right.
Wait a minute. That's not it. Wait a minute. Or maybe they must be doing something with the video right now. Because it won't let me get back to the video. I'm assuming they probably, because we were on TiVo time, that they are editing. I'm assuming that's what they doing. Yeah, so the string, yeah, they editing the video, so I'm not gonna be able to see it. Okay, let me see if I can find something where we can at least get. I mean, I would like to see at least what it looked like. They saying they updated, but it's not updated the thing yet. Okay. Gosh, that's what I'm talking about. That's a whole fight. Y'all can't see that. Let me see. Yes, I guess we still not gonna know. What? I'm pretty sure she went away for life. Like, I'm pretty sure she got life, but whatever. We will have to wait to get back in there or to figure that out. Okay, let me see here. Okay, so yeah, they took the feed, they edited the video, so I'll see. I can't see the CC. Left like your banner's in the way. Let me take that down for you. Yeah, I try to remember to pull the CC up. So if you ever see that, just remind me. I've been not putting the banner up there for our CC when we have our closed captioning, so we don't have that issue. I do know a lot of people were telling me about it in my little comment feed, so I just want to make sure that I do try to be mindful of it. But sometimes I want to let everybody know kind of what we're doing in a way while we're doing stuff. Okay, so let me do this. I am assuming, I don't know how long it takes for them to actually do that, guys. We do have our Zach Adams trial with our Holly Bobo part 2, right? So we can listen to the rest of our testimony for Jason Autry for today. Oh no, wait a minute. Oh, it's our gifted memberships that's covering it. Okay. It don't matter. We about to come out of this room anyways. Give me a second. I'm gonna get us back over here to our Zach. Guess who's back? Back again. Zach is back. Oh, he's not really back. I guess I can't sing his song when he's not really back, huh? Let's see here. Yeah, I didn't know how long that was gonna last. You say you feel like you so far behind, girl. You might be. No, I'm just playing. Day 2. Day 4. Live. Part 2. That's interesting. Hold on one second, guys. I am getting this all together, y'all. And then I'll drop the link in the chat, and then we could just move over there and continue on to our Zack Attack trial. For Halle Boo Boo. What is this called? Download. Upload. And this is going to be 42. I know. I was over here I'm trying to get our stuff together for our Thanksgiving Eve redrum trial that we're going to start tomorrow. So I was working on that. I hadn't went back and started working back on Halle Boo Boo. And we're going to do this now. 140. Okay. Let me get this up for y'all. You. That's the wrong one. You. Okay, guys. I am dropping the link for the new room and we'll go watch Zach. On our way out, I am going to go ahead and play our theme music. Once Core TV uploads once they upload the sentence part, I will bring that to you guys. Because like I said, I still haven't heard it. So I have no clue on how that works. I know it's because they're editing their video. I just wasn't, I didn't think we was that far behind, but I guess we were. Yeah, so if you want to click on that link, it'll take you right over there, and we'll continue with day 4, part 2 of our Holly Bobo testimony.
Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet P's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet P's in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Morelia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial, trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet P breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial, trial. When the sun sun goes down and the cases get deep. After dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight.